Good morning, Enrico.
Morning, Slupika. How's it?
I'm good and yourself.
I'm fine, thanks. Can't complain. Just the sinus that's a bit terrible this morning, man.
Now what the
The
flu?
sinus.
Oh, the
No,
sinus. I can, yeah, I
sinus.
can hear you. I can hear you. That the
Yeah.
feel is blocked.
Otherwise, I'm doing okay, Slupika. It's just the
No,
sinus.
that's good, man. That's good, man.
Yeah. I
Hey,
got.
tell me, man. I forgot the processes. I mean, we've got those two bills that we need to do the quotations and all that.
Yeah, yeah.
I'm waiting for translations from languages.
Okay.
Yeah. Are we still using Yandambanga, ne?
Yeah, they stole the service provider, Slupika.
Okay, okay.
They stole the service provider. Marcel did one now earlier in this year. And then she still asked me for some assistance. But then I sent her through those stuff that we did last year. Can you remember?
Yes, 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 yes.
Yeah, so I
No, it's
sent that.
fine. As soon as at least, I mean, those translations are come back, then at least we're gonna send a request
Well, yeah,
to
no.
Dean. Yeah, to Ayandambanga, yeah.
Okay,
At least I do
okay.
have Dean's cell number, then I can always talk to him.
Yes, yes. No, that's fine. That's fine. You can just
No,
let me
it's
know.
fine. If that is the case, then it's fine.
Yeah, you can just let me know, Slupeka.
Yeah.
No, you can just let me know.
Mm. All right. I'm not sure
Slupeka,
whether we should.
what did
Eh?
you say? What did you
I'm
say,
saying I'm not
Slupeka?
sure whether we'll be able to start on time because the
Yeah, because it's almost
chairpersons
quarter
and
to
whips
eight.
are attending another meeting
Yeah,
as we speak.
and it's
So it's,
also almost quarter to nine again.
yeah, but I spoke to chairperson and Mr. Khai. Yeah,
Yeah,
they
no,
will be.
they will come. They will come,
Mm,
Slupika.
okay.
Will come. I'm just gonna
Okay.
get. I'm just gonna get me some
I
coffee
sent
quickly.
you Miss Musho this request, so you saw it on
Yeah,
WhatsApp. Eh?
yes, I did reply back to you. So I'm just gonna ask Olivia. Olivia is no longer doing it, but I just want to ask you if she can maybe assist me with that.
Okay.
And who will be the correct person to speak to? But I
No,
will send Olivia an email. Okay,
okay,
Slupex.
no, it's fine.
Okay, Slupex.
Okay. Good morning, Chairperson. Good morning, honorable members. Good morning, colleagues and our guests. May I please check with the Socio-Economic Rights Institute if they are in, and for South Africa if they are in?
Yes, sir.
Chairperson,
How are you? How are
I'm
you?
good and yourself, Chair.
Good.
Uh,
By elections, I'm in an awkward situation, but at least I hope I'll be
oh,
fine.
okay. Yes.
Yes. Just want
No,
to
I
check
was
whether
just trying to
I.
check with our guests if they are in before we
Yes.
start.
Now, right now,
Yes. I'm not getting any
let's
response.
fly the program so that we can start the program.
Okay, Chair.
Yeah, no, I think it's fine. It's fine. Fine. You alert me when you are ready.
We are ready. It's 9 o'clock.
Let's check in terms of the. All right.
In terms of what, Chair?
Let's just probably let's do that in five. Just 5 minutes. Will 5 minutes. Can you do that?
5 minutes.
Yes.
Okay, Chair. Dr. Clark?
Good morning, Mr.
Good
Mclean.
morning. May you please round up with the stakeholders so that we
So,
can grant them permissions in this 5 minutes.
our first presenter is Mr. Molope from the Socioeconomic Rights Institute. Mr. Molope, are you with us?
Not in?
Not yet. Ms. Ellerbeck from For South Africa, are you with us this morning, ma'am? Dr. Jeffrey from Institute for Race Relations, are you with us this morning? Good morning, Mr. Molope. I see you've just joined.
Permission granted from Ms. Mulopi. Is it Mr. Mulopi or Ms. Mulopi?
Good morning, Dr. Jeffrey from Institute for Race Relations. Institute for Race Relations. I hope you're well this morning, ma'am. Good morning, Ms. Dallas. I hope you're well this morning. Shupeka, Ms. Dallas will present on behalf of the FW de Klerk Foundation.
Good morning. Would you like me to present now up first?
No, we're just ensuring that we've assigned presentation rights to all our speakers.
Oh, okay, great. Thank you so much.
Ms. Brown is also in Shupeka from the Mineral Council of South Africa.
Miss who?
Ms. Brown. Mr. Swart is also in Shupeka. He will be for the National Employees Association of South Africa. Mr. Swart.
Is it Jaco Swart?
Yep.
That's good.
Mr. Molope, are we audible on your side?
Yes, you are.
Okay, perfect.
Chairperson? Chairperson?
Can I just have a moment? Ms. Pretorius from For South Africa, can you advise if you will be delivering the presentation or if we are waiting for Ms. Alabate to join us?
Good morning. We're still waiting also for Ms. Ellerbeck. She will be joining us in about 5 minutes. Thank you.
Perfect. Thank you very much.
Thank you.
Yes, I'm ready now. Brother,
Chairperson?
I say I'm ready
Recording
now.
in progress.
Yes, we are ready. We are ready, Chair.
Oh, great. Let me then take this opportunity to extend a word of welcome to all the members of the Committee of Transport, Public Service and Administration, Public Works and Infrastructure, and Monitoring and Evaluation. This is the second leg of our meeting. We had an opportunity to start the discussion last time, but unfortunately we could not finish. And then we then agreed that we will meet today to continue with the public hearing on the Expropriation Bill. It's quite critical that we appreciate the fact that in terms of the work that we are doing, we are reflecting in terms of the Bill 23B 2020, which mainly is an attempt to amend the Expropriation Act of 1975 to make it in line with the new constitutional dispensation, but at the same time to ensure that we deal with key critical areas that affect property. We had an opportunity to be given a lecture by some experts on the concept of property itself. What does expropriation mean? What can be expropriated? What legislation enables expropriation? And then as following that, we then received a briefing from the department. But like as I said, this is a continuation of the work that we did. We just need to emphasize the fact that at least let's make sure that even though the program is 15 minutes, would appreciate if members can, if our guests, which we also want to extend a word of welcome to them, be precise to the point. We have received the presentation, but what is quite critical is just to make sure that your message is driven home. And in terms of our program, we are starting with the Socio-Economic Rights Institute. Mr. Imropi, the floor is yours.
Thank you, Chairperson. Good day to the committee members, and thank you for this opportunity. Chairperson, please, if I can just connect quickly from another device because I'm struggling with load shedding. So I've made means to connect to a different device that I would be able to share slides to and hopefully have a better connection there. I see I'm being able to do so.
Recording in progress.
Okay, thank you. I would also, if you can just allow me to share slides, and then we can start quickly. Thank you for indulgence, Chairperson.
Thank you, Mr. Mlobi. Can you help? You have been assigned co-hosting rights.
Okay, perfect. I hope you can see my slides.
And we can see your slides, Mr. Mlobi.
All right, perfect. Yeah, thank you. So thank you, Chairperson, for this opportunity to make our oral submission on the expropriation bill. I will get into it promptly. So I'm presenting from the Socio-Economic Rights Institute, SERI. We are a non-profit human rights organization. We work with communities, social movements.
If you don't mind, Mr. Mlobi, if you can just show your face for record purposes.
Oh yes, correct. That's correct. Sorry. Please let me know if that's. Okay, let me stop share, and then do this.
Oh, great! Now we can relate to the voice now. Thank you, Mr. Mlobi.
That's me right there. Yeah. Okay, so I'll do that again, share the slides. Let's see. And then I'll keep the video on. I think is that perfect?
That's great.
All right, perfect. Thank you, Chairperson. So we work with communities, social movements, individuals, and other non-profit organizations in South Africa, and beyond, really, to develop and implement strategies to challenge inequality and to realize socio-economic rights. And so a key component of our work, which is what brings us here, is that we advocate for the security of tenure and greater access for land for poor people. And the vast majority of our work is centered around making that greater access to land for the even poor. I will get into our comments on the bill. I think firstly, we'd just like to state that we see this expropriation bill as a welcome affirmation of the state's role in unlocking land for developmental and redistributive purposes. and you think that there are opportunities that are available to ensure that this is worked out within the bill itself, is situated within a thoroughly worked out program of urban land reform and land reform in general. But we do specifically focus on urban land reform because we think there is a lot of focus on land reform in general, but I think there is not enough in terms of urban land reform. And we think that expropriation works as a tool that can assist in terms of that program. So I'm going to make comments on 4 components, and then I will make a close, Chairperson. So the 4 things that I'm going to be looking at. The first one is expropriation as a method of land reform. And then I'm going to speak again then on the initiation and activation of expropriation. And then I'm going to speak on transparency monitoring and public participation in the bill. And then I'm then going to the last component is going to address the nil compensation provisions in the bill. So on the first one, on expropriation as a method of land reform, I think we are all quite aware, and I think it's agreed that the land reform project has not fully realized the promises that it had envisioned, that we are in a process or in a context where the land reform project has not made made fully the promises that it had promised. And so past attempts to make this redress and to redress the inequalities of distribution of land in South Africa still persists. So many communities to this day remain without tenure security and are often fighting eviction from the state and also from privately owned land. And so I think expropriation then is a tool that should be directed at securing tenure for the poor where they currently live. And I think it's quite important to stress the importance of where people currently live and the land that people are currently situated on. And so that's essentially, I think, where expropriation comes in as a tool to assist in terms of that as a method of urban land reform. And so we think that properly implemented expropriation can then be used to address the problems of insecure tenure in informal settlements and densely populated areas. Now, I think some of the difficulties then with expropriation is that expropriation, currently we have the Expropriation Act, and this bill seeks to bring in a new Expropriation Act. And so we have expropriation as a method, and it has been functioning. It has been present during apartheid, where the state used it as a method to advance the apartheid key legislation and the apartheid state visions. But then it was also, while it is present also to this day, it is a tool that is severely underutilized, particularly as it relates to issues of to issues of expropriating in the public interest. And so I think then what we think would assist, and we've made comments to where we particularly on section 3 of the bill, where we think that it might assist to ensure that we address the issues of tenure and also the participation and activation of expropriation by communities. is that, past experiences have shown us that we can't rely on the state to expropriate land in the public interest. And we've dealt with a couple of cases. I will state two cases now, just briefly. One is an informal settlement in Philippi in Cape Town, where 60,000 at the last count, 60,000 people were residing on that land. And as part of the process of, there was an eviction process that was instituted by the various landlords, and what the community then, proposed as a solution was that the state should expropriate that land for them. The city of Cape Town, the provincial Western Cape government opposed that proposal to expropriate that land, and instead always wanted to pursue the eviction matter. Another case is in the KwaZulu-Natal. There's an area called Matlock there. Same similar facts, where the community was being evicted. They came as a solution to say that we can consider the state should consider expropriating this land for the community. But the municipality, the Matlock municipality, opted to rather relocate the residents. So these are just some examples that where we see that if the communities don't have a way of initiating and activating expropriation, then it leaves this tool underutilized. And so I think it is important, what we are saying is that it is important that the voices of the landless are heard when it comes to issues of expropriation. They should be heard on what should be expropriated and when. And so a key to proper implementation of this process is to ensure that citizens have the power to activate expropriations, which is currently absent in the bill. The other aspect that we would like to address, Chairperson, is the issue of transparency and monitoring in the public and public participation in the process. I think what we have seen in current history is that there is a lot of elite capture, and there's a serious challenge in terms of elite capture in land reform efforts that have been conducted post the 1994 period. And so I think what Section 26 of the current bill speaks to, records that would be available. And we are saying that these records would then need to be also accessible to communities and activists, and not only be accessible at a higher level. And so I think that would also assist in terms of transparency and monitoring of this public participation process, to ensure that elite capture is not, it does not take place in the way that we have seen it take place. And some of the other recommendations, come from the high level panel that former President Kgalema Motlanthe chaired, where, there are issues coming in of land reform acts and the redistribution framework. And I think those are also some of the adoptions that we could look into in some way, or whether in this bill or in another, where we look at how we can ensure that some of these gains are not lost. We as SERI are part of a network called LandNest, which is a network of NGOs and land organizations that tries to work with the state and develop policy that will better assist people on the ground. And I think we would be willing with Landness to work with the committee and any other relevant body to ensure that what we are proposing here, if it is deemed relevant, that we could take it forward. I think, Chairperson, I'll draw to a conclusion looking at the nil compensation provisions that are in the bill. As SERI, we welcome these provisions, especially the inclusion of speculatively held land and abandoned land and land that possesses danger to people. I think we think it spreads the responsibility for the country's land reform program and reducing the anticipated burden on the state coffers. I think the bill makes provisions for where that would be suitable. So it's not all circumstances because where nil compensation provisions would apply, but where those do apply, we support those provisions. I'll conclude there, Chair, by simply stating that we welcome the bill. And we also welcome the provisions for nil compensation, as we think that it strengthens the state's land in the expropriation process. And we think that this bill is an important milestone in the journey for land reform. Thank you for the opportunity, Chairperson.
Thank you, Mr. Molopi, on behalf of SERI for taking us into confidence in terms of the thrust of the presentation. It's highly appreciated. Just want to check from members whether they want to raise any clarity-seeking question from their side. Any clarity-seeking question? I guess you are very clear, Mr. Molobi. Thank you for honoring our invite and also making the voice of the voiceless heard on behalf of SERI. We'll continue to take cognizance of the thrust of your presentation. Thank you a lot. Have a wonderful day. Thank you, Mr. Molobi.
Thank you, Chairperson. Pleasure is all of mine.
Right. Thank you. We will now move to the second presentation, which will be done by Mr. Ellerberg on behalf of For South Africa.
Good morning, Chairperson. It's Miss Ellerberg.
Daniela, thank you.
Yes.
Right. The floor is yours. You have 15 minutes, but if you can do it in 10 minutes, that will be highly appreciated.
Wonderful. We'll try our best. If the host could just enable screen sharing, please.
Great.
Chairperson, just to say we've joined you now.
Thank you, Ambassador. Can we help Mr. Albert with hosting rights? Chupega or Enrico? You have the rights.
Thank you, Chairperson. Right. Honorable Chairperson and other members of the esteemed committee, thank you for inviting 4SA to participate in this meeting and to present our input on the Expropriation Bill. We trust that our submission will be brief, that it will provide a unique perspective that will assist the committee in drafting a law that practically benefits South Africa. I am Daniela Ellerbeck, an attorney and the legal advisor to Freedom of Religion South Africa, commonly known as 4SA. Joining me online is my colleague, Mrs. Liesel Pretorius, also an attorney and serving as the legal advisor at 4SA. So 4SA currently has an endorsement base of religious leaders representing millions of people in South Africa. Our constituency spans various denominations, churches, and faith groups. So, for example, in the lockdown matter, we were mandated by religious leaders' organizations representing between 11 and 18.5 million people from a cross-spectrum of churches, denominations, and faith groups, including 10 million people from the African indigenous and spirituality churches. And we were mandated on their behalf to engage with government and make submissions on their behalf. As such, and because the constitutional rights to freedom of conscience, religion, thought, belief, and opinion, commonly known shorthand just as religious freedom, And the right to practice one's faith in community and form and join and establish religious associations, which we'll just call religious communities' rights, are directly affected by any law that could potentially affect the ability of the millions of believers in South Africa to meet together in buildings located on land to exercise their constitutional rights. Our constituency has a direct interest in this matter. Now, turning to areas that 4SA works before, we work before government, parliament, and Chapter 9 institutions, as well as the courts. Ms. Pretorius?
Good morning, Chairperson. Good morning, committee members. I will deal with the ambit of religious freedom. So, religious freedom is a right that is protected in Section 15 of the Constitution. And Section 15 of the Constitution says that everyone has the right to freedom of conscience, religion, thought, belief, and opinion. And every week, millions of believers across different denominations, churches, and faith groups believe that their particular holy text, whatever it might be, commands them meeting together, and consequently doing so, that meeting together, coming together, is an integral part of practicing and living out their beliefs, their right to religious freedom. Now, in this regard, the Constitutional Court has repeatedly held that religious freedom includes the right not only to entertain such religious beliefs as a person's choose, but the right to declare religious beliefs openly and without fear of hindrance or reprisal, and the right to manifest religious beliefs by worship, by practice and teaching and dissemination. Thus, the places where these religious meetings happen are a central part and indeed of critical importance to believers for living out their rights in terms of Section 15 and Section 31 of the Constitution. Every believer should be free to believe and practice, of course, within the bounds of the law, what they believe their religious texts command, and to live out their faith in community with others, including meeting together to worship, to take holy sacraments, receive teaching, and fellowship. Now, turning to constitutional considerations, in terms of Section 18, sub 1 of the Constitution, we know that the Bill of Rights applies to all laws and it binds the state, including Parliament. And furthermore, Section 7, sub 2 of the Constitution requires the state to respect, protect, promote, and fulfill all the rights in the Bill of Rights. Now, when it comes to limiting a right, Section 7, sub 3 of the Constitution states that the right contained in the Bill of Rights can only be limited in terms of Section 36, the Limitations Clause, or elsewhere in the Bill of Rights. Now, Section 36(1) states that the right contained in the Bill of Rights can only be limited by a law of general application. For example, the Expropriation Bill would be a law of general application, but then only to the extent that it is reasonable and justifiable in an open and democratic society and subject to several factors that must be taken into consideration. It's also very important to note, and our Constitutional Court has confirmed this numerous times, that the Constitution knows no hierarchy of rights. That means rights should not be construed absolutely or individualistically in ways that deny that all individuals are members of a community. Again, I wish to reiterate that the Constitution requires the state, including Parliament, to promote all rights in the Bill of Rights without preferring one over the other. So that's our constitutional context. Then let's turn to the international law protection of freedom of religion. Now, as you can see from the slide, South Africa has ratified many international treaties and declarations. So these are binding on South Africa. And all these instruments are explicit in their protection of religious freedom, which includes the freedom to practice your faith in community with others, meeting together with others. More detail on this is in our written submissions. Now we will turn to our concerns. And the first part of our concerns procedural concerns. Now, Parliament, you will be aware that there was the Constitution 18th Amendment Bill of B18 of 2021. And that bill aims specifically at amending Section 25 of the Constitution, the property clause, as you know, to allow expressly for expropriation without compensation. But on 7 December 2021, Parliament rejected that bill. Now, given that the Constitution has been specifically not amended to allow for expropriation without compensation, passing subsidiary legislation, means legislation subject to the Constitution, such as this expropriation bill that we're talking about today, would immediately open the bill to a constitutional challenge for being inconsistent with the Constitution. Parliament has expressly chosen not to amend the Constitution to allow for expropriation without compensation. So for this reason, Parliament cannot give the Minister of Public Works and Infrastructure the power to expropriate property for no compensation, which is no compensation. So to the extent that the bill includes provisions to this effect, it is arguably contrary to the rule of law, which requires the government to operate within the powers conferred to it by the Constitution. That's the government's boundaries. Government derives its power from the Constitution, and when the Constitution expressly not being amended to allow for expropriation without compensation, conferring such powers in on the minister would be illegitimate and contrary to the rule of law's principle of legality. So therefore, in order to ensure constitutional compliance and to honor the rule of law, 4SA urges the committee to approach the Constitutional Court for a declaratory order regarding whether nil compensation to be paid, in other words, expropriation without compensation, as proposed in clauses 12 sub 3 and 12 sub 4 of the bill, would qualify as just and equitable payment, and thus whether that would determine whether expropriation without compensation is constitutional under section 25 sub 8 sub 23 of the Constitution as it currently reads. So any measures taken by the state, any measures taken by the state concerning socioeconomic rights must also pass the constitutional standard of reasonableness. Parliament is now set to draft and promulgate a new legislative measure, this expropriation bill, which will have a wide-reaching effect on the nation, all while the issue of expropriation without compensation has and remains hotly disputed. So for this reason, we are concerned as an organization that the first port of call should be to ascertain from the Constitutional Court, our highest authority on the Constitution, whether expropriation without compensation is constitutional or not. To do otherwise, we would say, is putting the cart before the horse, and that risks falling short of the said standard of reasonableness. And with that, I hand back over to Mrs. Ellerbeck for our substantive concerns.
Thank you, Ms. Pretorius. Turning to our substantive concerns, our first concern as an organization is the definition of property, because the bill currently defines property as contemplated in Section 25 of the Constitution. Now, Section 25 of the Constitution doesn't limit property to just land. And as a result, all property from immovable to trademarks become encompassed by this bill and subject to possible state expropriation. So 4SA is of the view that this definition should be specifically limited in the expropriation bill, as the bill clearly intends to deal with and relates to immovable property, specifically land and appropriate affected land-related property rights, not intellectual property or shares and so forth. Our second concern is the definition of public interest, because clause 1 currently defines public interest merely as including the nation's commitment to land reform and to reforms to bring about equitable access to all South Africa's natural resources in order to address the results of past racial discriminatory laws or practices. Now, 4SA submits that this definition should be aligned more to the Bundle Charter, one of the international instruments binding on South Africa, by including, quote, to meet a public need, end quote. In other words, that definition needs to read as follows: public interest includes the nation's commitment to land reform to meet a public need, and so forth. And we submit that absent clear definitions in respect of the foregoing terms, so property and public interest, the bill is in danger of being open to abuse by future political dispensations. Turning to the hotly debated issue of expropriation without compensation. Currently, clause 12.3 of the bill only relates to land and provides that where land is expropriated in the public interest. And 4SA strongly objects to the list not being a closed list, and that no exceptions to property that can be expropriated are provided for, so that the list is not closed and no exemptions are given. And furthermore, given that, as my colleague Ms. Pretorius said, that Parliament rejected a bill aiming to amend the Constitution less than 2 years ago, we submit as an organization that it's highly doubtful whether Clause 12.3 will be seen as being reasonable. And as a result, it will likely be unconstitutional. Now, going on further with EWC, as clear from the slide, the result is that the bill limits certain fundamental rights, including religious freedom. And a critical question, given that it limits fundamental rights, is whether expropriation without compensation of faith-based institutions' property is a reasonable and justifiable limitation on religious freedom and the right of religious communities to own such property. Now, in our written submission, 4SA does an extensive Section 36 analysis, but for time purposes, I will only look at the one factor related here, namely the relation between the limitation and its purpose. Now, given that the high-level panel report specifically says that when looking at land reform, one, policy shifted away from constitutional imperatives such as equitable access to land towards state ownership, which echoes apartheid-style notions of custodianship. Secondly, that land reform policy has drifted from its initial pro-poor focus to one marked by signs of elite capture. Implementation has also been dysfunctional. And lastly, the need to pay compensation has not been the most serious constraint on land reform in South Africa to date. Rather, other constraints including increasing evidence of corruption, the diversion of land reform budgets to elite, lack of political will, and lack of training and capacity have proved more serious stumbling blocks to land reform. So these are three of the reasons that the high-level panel report found that land reform has hit almost a bit of a bottleneck in the country. And it's clear from these, it's not the lack of funding that's the cause for the slow pace of land reform. And given the causes identified, the problems, EWC seems to be the wrong remedy for the problem. And a remedy that bears with it the likely and indeed inevitable consequences of degrading South Africa's economy, which is already in dire straits, even further in the eyes of international investors. And for this reason, 4SA strongly emphasizes that EWC currently is unlikely to meet the Section 36 requirement because it fails to meet the necessity of a relationship between the remedy and its purpose. And on this ground alone, we respectfully submit that EWC is not reasonable and justifiable. Rather, the bill should aim to give a coherent framework law for land reform that roots out the maladministration and corruption that has happened to date. And to achieve this, surely the bill should first and foremost address what has been identified as the actual problems to land reform, namely corruption, elite capture, and maladministration. Now, turning to Clause 12.4, which provides that it is competent for a court or arbitrator to determine no compensation to be paid, having regard to all the relevant circumstances, which are undefined and not linked to the list in Clause 12, subsection 3. It is highly unlikely to pass constitutional muster in light of the rule of law concerns and the standard of reasonableness concerns raised in our written submissions, specifically in paragraphs 14 through 16 and paragraph 39 through 3 in our written submission. Turning to urgent expropriation, Clause 21 allows for an expropriating authority to temporarily use property at urgent requirements for up to 18 months. And Clause 22 sets out the circumstances under which this may be done and states that such urgent expropriation can be done in terms of the Disaster Management Act, or DMA, or in terms of court order. Now, in light of both the COVID pandemic, which resulted in South Africa being in a continual state of disaster from the 15th of March 2020 through to the 5th of April 2022, and the fact that power supply difficulties experienced by Eskom resulted in South Africa again being in a state of national disaster from 9 February 2023 onwards. 4SA strongly objects to Clause 22A, which allows for expropriation of property without any judicial oversight, where a matter is of utter urgency, an urgent court order can be obtained. And I now hand over to my colleague, Liesel.
Thank you, Ms. Ellerbeck. Now we will turn to our recommendations. Our first recommendation is that the definition of property in Clause 1 of the bill be limited to land and appropriate affected land property rights only. Secondly, we recommend that the definition of public interest in Clause 1 be aligned to the Bandel Charter. on African people's rights by including the words to meet a public need. In other words, the definition will then read, public interest includes the nation's commitment to land reform to meet a public need, etc. Our third recommendation is that clause 12 sub 3 of the bill be removed. Alternatively, that the criteria for expropriation without compensation be a closed list. Then our further recommendation is that clause 12 sub 4 be removed. Alternatively, that the phrase all the relevant circumstances be either defined or linked to the list, the closed list in clause 12 sub 3. Then we recommend that a clause containing exemption clause basically be inserted, a clause about land that is exempt from expropriation without compensation. And our proposal for such a clause reads, land that is owned and used in connection with the exercise of the constitutional right to religious freedom and the rights of religious communities is hereby exempted from the applicability of sections 12 sub 3 and 12 sub 4. Then we also recommend that clause 20 sub 2a be removed. Alternatively, that there is express provision made for judicial oversight when that clause is exercised. We further urge the committee again to approach the Constitutional Court for a declaratory order regarding whether nil compensation, in other words, EWC, as proposed by clauses 12 sub 3 and sub 4 of the bill, qualify as just and equitable payment, so that there is no constitutional uncertainty. This will achieve the clarity regarding expropriation without compensation that we believe is absolutely necessary before proceeding with this bill. That concludes our recommendations. We thank the committee chairperson, honourable members, for allowing 4SA to present our concerns and recommendations to you, and we look forward to answering any questions that you may have for us. Thank you.
Thank you, Ms. Pretorius and Ms. Alabak for your exchange in terms of presentation. Job well done. Let me check from members. Any contesting questions? Questions. I think members are quite comfortable with the manner in which you presented. You were very clear in terms of your areas of emphasis, both procedural, substantive, and then the recommendations, complete recommendations that you are making. You made our work very easy in terms of where the community should focus. And have a wonderful day, Ms. Pretorius and Ms. Alabek, for helping us in terms of. Oh, okay, my apology, Honorable Khai. Oh yeah, since there are two hands, I was in a hurry. Honorable Khai.
Thank you very much, Honorable Chairperson, and greetings to the representatives of for South Africa and also other stakeholders and honorable members. Chair, I think most of the input by for South Africa will be things subjected to our continued discussion, because there are a lot of other there are also other stakeholders that will be making inputs, and also the inputs from the provinces. I would say the points that they are raising don't require questions for now. They will be subject of deliberation after we've engaged with all the other inputs from the stakeholders, including the negotiating mandates from the provinces. But just one issue on the recommendation, I want clarity on. The presenter says that in terms of definition of property, should be limited only to land, but the Constitution says in terms of Section 25(4)(b) says property is not limited to land. So already that recommendation goes against the Constitution. I would like to hear how do they go around that issue in terms of their interpretation? Thank you so much, Honorable Chair.
Thank you, Honorable High. Honorable Professor.
Thank you, Honorable Chairperson. Just a very quick question. First of all, thank you for the presentation from 4SA. The quick question to the presenters is, are you planning a constitutional court challenge should this bill pass? Thank you.
Thank you, Honorable Professor, for that clarification question. The team can then take the platform to respond.
Thank you, Honourable Chairperson, and thank you for appreciating the work that 4SA did with putting forward the recommendations. We strive to make honourable members' job as easy as possible. We know how busy you are. Turning to Honourable Khai's question on the fact that the Constitution doesn't limit property to just land and why we say that the bill needs to limit property to just land. The answer, Honourable Khai, is very simple. Is the fact that the bill deals, and the purpose of this bill is to deal with land reform. So in order to achieve its purpose, this bill should only focus on land and appropriate property-related rights, such as buildings and so forth. Because if it doesn't, for example, if Honourable Khai had a son and your son was a brainiac and solved the sustainable energy crisis, because of the way the bill currently is worded, it would allow any future political dispensation to expropriate his ideas and his intellectual property without ever paying him for it. And that would become state property. And that clearly is not the intention of this bill. So in order for the bill to actually achieve its intention, it needs to be limiting the definition of property to actually only deal with land and appropriate land-related rights. Turning to Honourable Broughton-Smith's question, Honourable Broughton-Smith, I currently do not hold instructions with regards to that, and I'm not in a position to answer. Sorry, that's a very lawyer answer to your question, but I hope it suffices.
Maybe the question would be.
So, Chairperson, I have a follow-up.
Yes, Tim, but you raised the hand before your question was responded to Honourable Broughton-Smith. Over to you.
Chairperson, I'm sorry. To I think it's Ms. Pretorius and Mrs. Ellerbeck.
Ellerbeck, yes.
I need to challenge you on something. You stated just now that this was a bill intended for land reform. And I need to challenge you in the strongest terms on that. This bill is an expropriation bill. It's supposed to be for the public good, where the bill is intended to expropriate land in order to facilitate the building of a road, a hospital, an airport, whatever the case may be. And surely the problem with the wide definition of it is that it starts turning it into a land reform bill, because public interest then comes into the public interest clause then comes into play. So I'm just very concerned that from your presentation, you were talking about an expropriation bill, and now you're effectively saying that this bill is intended to be a land reform bill. And I certainly know it's a very strong contention that this is not a land reform bill. It's a normal expropriation bill with numerous concerns around which property can be expropriated. If you could just address us on those issues, I'd really appreciate that. Thank you.
Yes, maybe just another question. I guess you are well conversant with the current legislation on expropriation that is in place. From yourself, and given the fact that, as you have correctly pointed out, that it was used in the past by the apartheid to advance a particular agenda, do you agree that indeed there is a need to amend the bill to make it in line with our constitutional dispensation? Secondly, the definition of property, as you have correctly pointed out, will also include real rights. It will include servitudes, where in certain instances the expropriation might be necessary for the servitude. Just to get a sense, but also there will also be competing rights sometimes, whether it is intellectual property rights. Those are also part of the property. Those are also inalienable rights. Just to get a sense from yourself, because your angle is more from the religious point of view, and the assumption is that, as you have correctly pointed out, there is no right in the Constitution that is absolute. Hence, you also made reference to the limitation clause in terms of Section 36. Just in terms of your response to that.
Me unmute myself, that will always help. Honorable Bratuseth, I agree with you. It is an expropriation bill to the extent that I said land reform. The reason for that is that when Forest A read that bill, it seems to focus on land, but because of the wide definition of property, that does allow for example, intellectual property to be expropriated without compensation, such as, for example, the example I used with Honorable Khai and sustainable energy. So looking at the bill in its entirety, the impression it creates is that it's meant to focus on land and giving everyone equal access to land. At least that's the impression that we as two attorneys gathered from it and got from it when we read it. And that's also why we said that it actually needs to limit it to land, because and Honorable Chairperson, land and we said appropriate land related rights, such as real rights, for example, and servitudes, that would fall within that. But because of the wide definition of property at the moment, it does open up, for example, intellectual property, movable property like the clothes on your back, to be expropriated without compensation, which isn't, when you look at the context of the bill, taking it its entirety, that doesn't seem to be the purpose of the bill at all. And that was our reading of it. Honorable Chairperson, does that sufficiently answer all the questions? Mrs. Pretorius? Yes.
Thank you, Ms. Ellerbeck. Yes, we understand that the bill does say that, if property is not land, it does qualify for that. But as Ms. Ellerbeck said, the general purport of this bill is that it's focused on land and land-related property rights. It would be strange to argue, because the definition is property is so wide, it could mean the clothes on somebody's back. It could be the books on your shelf, teacups and spoons in your drawers, intellectual property. It's very wide. And when it goes that wide, it will need a whole other level of consideration, deliberation to ensure that fundamental constitutional rights are protected. Because as we have said, the Constitution knows no hierarchy of rights. And when a right in the Constitution is limited, there's a very strict Section 36 limitations test that needs to be complied with. And rights should not be limited more than necessary. If there's a less restrictive means to achieve a purpose, constitutionally, you should go to that. You want to maximize the enjoyment of fundamental rights of all people. And if you look at, for example, this definition of public interest that the bill uses, it says public interest includes the nation's commitment to land reform. So land reform seems to be the strongest theme in this bill, read as a whole. And that's why we say to land and appropriate affected land-related property rights. Because if you expropriate land, there might be a business there might be intellectual, there might be, water rights, etc., mineral rights, things connected to that. But it's just to keep it within an ambit that is kind of and with an amber that is sensible. But as you has correctly said, Chairperson, our focus is the fundamental right to religious freedom, and that's, we limit ourselves to that. Our concern is that that religious groups do not lose their property, their church, their mosque, their shul, and in their property. And if it's property is everything, does it mean that they potentially could use, I know, their sound equipment, their books, the things that are in the church kitchen? So that's why we say it's sensible within the ambit of this bill to limit it to land and appropriate affected land-related property rights. And if it goes wider than that, that's something that the committee should intensely deliberate, and even perhaps with that declaratory order that we recommended that the committee approaches the Constitutional Court for concerning the issue of expropriation without compensation, to just see how should other property rights be affected in this context, what's constitutional, what's not, where's that line? I hope that answers the question. Thank you, Chair.
Thank you. Is that a follow-up, Tim?
Yes, Chairperson, it is. I'd just like to ask both presenters, Daniela and Liesl, if you don't mind me using your first names. Isn't that the fundamental flaw with the bill? Is that it's called an expropriation bill, but it looks like a land reform bill. And making this particular bill a land reform bill is like going around and trying to come in with expropriation without compensation through the back door. And isn't that the fundamental flaw? Because when we were presented, when the department presented to us, their advocate said the department needs to have as free a hand as possible to expropriate whatever it wants, including the clothing on your back. And obviously that is very, very concerning, because what about business rights? What about the rights to your artwork, the rights to your literary work, etc., etc., etc.? It includes all of that. So do you not see that as a fundamental flaw in the bill, is that it's either too wide or too narrow, but it can't be both. It can't be all things to all men, as it were. If you could just address us on that, thanks.
Honourable Broughton. Thank you, Honourable Chairperson. Honourable Broughton said, again, one of the things that the committee will need to look at is whether or not, because this bill affects fundamental rights, it is satisfied as a committee that this bill passes Section 36. And specifically, the factor that Foyers focused on our presentation this morning is the purpose of the bill, and whether or not it actually achieves that purpose, like the relationship between its purpose and the means used for it, that factor that we looked at. And if the goal of this bill is to be an expropriation bill in name, but it is a land reform bill in the rest of the bill, one does need to look at whether or not it actually will pass Section 36. Ms. Pretorius?
Thank you, Ms. Ellerbeck. Yes, I wanted to say, Honourable Broughton says that I think that is an excellent observation. It is a feature of legislation sometimes that it can be both too wide and too narrow, and that is problematic. The bill needs to be written in such a way that it actually gives effect and aligns to its substantive purpose. There's a saying, if it walks like a duck and it quacks like a duck, it probably is a duck. But from our perspective, that's why the bill needs to be deliberated carefully. That's why there are important constitutional issues to be addressed, that it does not lead to absurdities that go beyond the scope of that which is allowed by the Constitution. Thank you.
Thank you, Team Ellerbeck and Team and Ms. Pretorius for your response to the members' clarifying questions, and we really appreciate that. And have a wonderful day, and thank you for honoring our invite to enrich our engagement on this bill. Thank you.
Thank you, Chairperson.
Thank you. We will now move to the next presentation, which will be South African Institute of Race for Race Relations, which will be done by Dr. Jeffrey. Dr. Jeffrey, the floor is yours.
Thank you, Honourable Chairman, and I very much appreciate the opportunity to address all the members of the Select Committee today. I would be grateful if I could be given the possibility to share my screen.
Thank you. Can you help Dr. Jeffrey, Committee Secretary?
Chairperson, the rights already been granted.
Thank you.
Thank you. Thank you.
There you are, Doc.
I hope that everything is visible and audible to the members of the committee in particular.
Indeed, it is visible and audible too.
Thank you. Then let me again reiterate my thanks to the committee for giving us the opportunity to speak. I'm not going to go in detail through what the presentation will cover. We'll see it in time. I'd like to start by emphasizing that the IRR does agree with the need for a better expropriation bill that is fully in line with the Constitution. But the bill before the National Council of Provinces, even as amended, suffers still from numerous defects, and it's also still unconstitutional. So we would like to outline some of the defects and the risks, and then to end with some constructive suggestions on how the bill could be rectified to bring it into line with the Constitution, international best practice, and the goal of increased wealth for all. The bill is, of course, enormously important, partly because it covers property of all kinds and not only land. Unfortunately, it cannot take land reform from failure to success. Between 50 and 70% of transferred land has fallen out of production and failed to help its intended beneficiaries. And this is because land is only one out of many factors that are necessary for success in farming. Also needed are individual ownership, working capital, electricity, labor, markets, transport, and the like. And we heard from the high-level panel of Parliament that land costs are not the key problem. And yet that is what the bill seeks to address, and not all the other issues. The bill will harm many Black South Africans who own houses, now 9.75 million of them, who have pension savings, who've bought land on the open market since 1991. I'd like to quote the example, first of all, of Becky Dlamini, who had 3,000 hectares of land in the Groteful area of KwaZulu-Natal, and who discovered to his astonishment around about 2013 that his land was now registered in the name of the municipality, which said it had served an expropriation notice on him under our current act. But he never received that notice, and he never got the compensation he was offered. And eventually, when he was able to get to court with the help of an NGO, he was told that it was too late to offer him any relief. This bill will not expand Black property ownership because that is not the intention of the government. The government's policy is rather as reflected in the State Land Lease and Disposal Policy of 2013, under which Black farmers must lease land from the state for 20 years and then another 30 years. So it's for 50 years in total before they can have an option to buy. And the risk rule was applied to David Ragasi, very experienced, successful farmer who wanted ownership of the land he had been leasing for many years. Even though he was 77 at the time, he was told that he had to lease for another 50 years, by which time, of course, he would be 127, or other words, long dead. And it was only because the government under Thabo Mbeki had agreed to sell him the land back in 2002 that he was finally able to obtain ownership of it in 2019, 17 years later. If we look to the bill and its very highly damaging provisions, among the worst are the nil compensation ones, which will have enormously negative economic consequences. In addition, from the point of view of the law, it's an open list, which means that nobody knows how far nil compensation may extend. The terms are very vague, difficult to apply, sure to be applied in different ways at different times. And by allowing nil compensation for land where owners have lost control, this will be an incitement to land invasions and illegal mining, of which we already have far too much. The definition of expropriation is too narrow. It's not in keeping with international law, and it may lead to nil payment on custodial and regulatory takings. We know that in 2014, the government put forward a bill under which all agricultural land would have been vested in the custodianship of the state. Once this bill has been passed, legislation of a similar kind could be put forward to vest again all agricultural land in the custodianship of the state. And the consequence will be that all private ownership will be lost, that all the previous owners will become tenants of the state, that there will be less production on farms because it will be hard to raise working capital, that there will be higher food prices to the detriment of all South Africans. There may also be regulatory takings in many spheres. For example, prescribed asset rules could compel pension funds to invest in Eskom and other failing SOEs, and the result will be reduced pension savings for teachers and other public servants and a whole range of other South Africans. And yet there will be no compensation at all for those who lose either land or pension savings, because in the view of the bill, there will have been no expropriation calling for compensation. If we look at the bill's damaging provisions, let me also recognize that some are okay. The preliminary steps to be taken before an expropriation proceeds are fair. But what really counts are the procedures that apply on expropriation. And there, the rules are still unreasonable. And in essence, people will generally lose ownership and possession long before cases can come before the courts. There's still only one clear time limit in the bill, that ownership cannot pass to the state before a notice of expropriation is served. So if the notice is served on the 1st of November, the ownership can't pass on the last day of October. But there's nothing to stop the ownership from passing on the 2nd of November, which is an extraordinarily short period with great detriment for all those affected. And though the expropriated owner will in theory have 180 days in which to challenge both the validity of the expropriation and the amount of compensation, in practice litigation is always expensive and risky and will be particularly difficult here, where the owner has already lost the property, is scrambling to find a new home or a new farm, where he knows that he probably bears reverse onus of proof to show that the compensation is not enough, that he fails to convince a court of that, then he risks an adverse costs order, in terms of which he will have to pay many of the legal expenses of the state, in addition to his own heavy costs. Compensation in general will either be nil or it will be well below market value. That's the whole purpose of having this bill structured the way that it is. And this will have major implications for the banking sector as well. If the property which is expropriated is subject to a mortgage bond, the mortgage will come to an end when ownership passes to the state, but the underlying mortgage debt will not. And if the compensation provided is less than the amount of the mortgage debt, the expropriated owner will battle to pay that off, especially there he is, battling with the consequences of having lost his property so fast and not being able to show that what the state has done is wrong. So defaults will increase. That means that land can no longer be used as collateral for bank loans. And we risk a banking crisis, as the Banking Association of South Africa has warned, and as experience in Zimbabwe confirms. Some changes have been made to the bill, but they don't solve these problems. One significant clause potentially says that notice of expropriation must include the amount of compensation as agreed or as decided by a court under Section 19. And I've emphasized those last words, because Section 19 deals with litigation on compensation after the notice of expropriation has been served, and probably after, therefore, ownership has already passed to the state. Again, there's another clause which has some limiting effect on the passing of ownership. Now, notice of expropriation must include a future date of expropriation, wording which was not there before. This at least suggests that ownership cannot pass immediately on service, as was suggested by Johannes Lekala, the Deputy Director Expropriation in the Department of Public Works and Infrastructure, who recently stressed that owners will lose their property. It will be transferred to the state immediately the notice of expropriation is served. This reference to a future date indicates that that alone is wrong, but it's still does not prevent ownership passing to the state far too quickly. Overall, people will generally lose both ownership and the right to possession long before that they can approach the courts for relief under Section 19. And so the new provisions will really not help them. They will still find it too hard to litigate in this situation, and the new clause will in practice be meaningless. I suggest that the words under Section 19 should be removed from Clause 8.3g, and then the clause would be much better. Other changes have been made. They're also not helpful to owners, and they also don't cure the unconstitutionality of the bill. I don't have time to go through them all now, but they are all dealt with in full in our written submission. I'd like to turn to the context against which this bill is being adopted, and the fact that our economy is enormously struggling already, that GDP shrunk dramatically during the COVID-19 lockdown, that it's barely recovered to where it was before then at this point, that joblessness is at crisis levels, that public debt is rising to crisis levels, that we could end up with a budget deficit this year at 6.5% of GDP. So what we most need is investment that will help to generate growth, jobs, and prosperity, but the bill will make that more difficult. It's also contrary to the ANC's Nasrec resolutions back in 2017, where the ANC said that EWC should be available as an option for land reform, provided it did not destabilize the agricultural sector or endanger food security or limit growth, and the bill meets none of those conditions. We also only have to look north to Zimbabwe to see what EWC provisions can do. There's now a 70% jobless rate, a great deal of hunger, hyperinflation, increased poverty, and of course, millions have fled the country, as we well know. In Venezuela, GDP after the expropriation, often without compensation, of around 20% of productive farmland and various other assets, has shrunk by 70% in a decade. Again, there's hunger, hyperinflation, increased poverty, and 7 million out of a population of 30 million have fled. I'd also like to talk about the importance of property rights, because prosperity does not come from land and natural resources. And the key example of this is Singapore, which is a tiny little island state with no land and no natural resources, and yet it's one of the wealthiest countries in the world, with GDP per capita of more than 67,000 Rand in 2022, compared to a rather meager 6,000 in South Africa in that year. Prosperity requires respect for property rights, plus limits on governmental power. And this has been confirmed over decades by the Fraser Institute in Canada, which has closely researched this issue. In 2022, the Fraser Institute found that average GDP per capita was more than $48,000 in the states that best protect property rights and limit state power, whereas average GDP per capita was only $6,500 in the states that do the worst on this. In addition, the average income of the poorest 10% was more than $14,000 in the states that best protect property rights, and only $1,700 in the worst ones. Moreover, extreme poverty at $1.90 a day afflicts 2% of the population in the best states, but 31%, almost a third of the population in the worst states. The bill is also unconstitutional. It fixes two obvious defects in the current Expropriation Act of 1975, but it leaves the biggest one untouched. It still allows an expropriating authority, after completing some preliminary steps, to take ownership and possession of land and other property by serving a notice of expropriation on the owner. But the Constitution requires a prior court order confirming that the proposed expropriation is valid, that it is really in the public interest, and deciding what compensation would be just and equitable in all the circumstances. And the bill already acknowledges that a prior court order is needed for inspectors to enter onto property or for temporary expropriations in most instances, and to extend a temporary expropriation from 12 to 18 months. But a prior court order is also needed for a permanent expropriation, which is a far more serious thing than an investigation or a temporary use of property. The bill is also unconstitutional in that it does allow this disputed expropriation to proceed without a prior court order. That conflicts with Section 25, the Property Clause, which is very clear on what is required instead. It also conflicts with Section 33, the right to administrative justice. Instead, it allows an expropriating authority to act as judge and jury in its own cause. It conflicts with Section 34, the right of access to court, to have disputes decided. The nil compensation clauses are particularly problematic. They are vague. They also contradict Section 25, of course. There's no pretense of an equitable balance between the public interest in land reform and the interests of the affected owner. They're in breach of Section 1, which upholds the supremacy of the rule of law, and the rule of law requires certainty. They undermine Section 9, equality before the law, and also Section 11 with its guarantee of human dignity. The definition of expropriation is too narrow, not in keeping with international law, and not justified by the ABSA decision, where the judgment was based purely on the facts of the case before the Constitutional Court, and no general principle of law was laid down. In conclusion, I'd like to sketch the changes that are needed to bring the bill into line with the Constitution. First of all, we should replace the definition of expropriation, use what is common in international law, perhaps draw on the wording that we already have in our bilateral investment treaties with China and Russia. We should remove the nil compensation provisions for all the reasons earlier discussed. We should require a prior court order for disputed permanent expropriations, just as the bill already requires a prior court order for temporary expropriations and for inspections. An expropriating authority must prove the validity of its proposed expropriation and of the compensation that it is offering, and attach a court order confirming that both are in order before it issues a notice of expropriation. The court order must go with the notice. In addition, appropriate time periods for the passing of ownership and possession must be inserted, for example, 180 days for the passing of ownership. The compensation must be paid in full before ownership passes. We know, unfortunately, that our government is often very tardy in paying amounts that it owes. And if that payment is not made, then the notice of expropriation should become invalid and should fall away. And we should also make sure that compensation includes damages for direct losses, such as moving costs, for loss of income as a result of the expropriation, for the loss where the compensation is less than the amount owing on a mortgage bond, and the expropriated owner in some way still has to find that money and pay off the debt. This would be fully in keeping with what the Constitution provides, and it's necessary if the bill is to strike an appropriate balance between the public interest in land reform and the interests of expropriated owners. This, in a nutshell, are the clauses that and the recommendations that we would make for change. We have set them out in full in our written submission, and we have also, to aid the Select Committee in its work, crafted an alternative bill in which all these changes are set out, so that wording is already available to the Select Committee to help it. Thank you.
Thank you, Doc, for taking us through the presentation on behalf of the South African Institute for Race Relations. The floor will now be open to members for 30 questions. So just one question from myself while members are still trying to find their feet. The fact that there are various pieces of legislation in terms of which state may expropriate For example, you will have Section 26 of the Extension of Security of Tenure Act, Act 2 of 1997. You will have Section 38 of the Communal Land Right Act 11 of 2004. You will also have Section 32 of the Petroleum Pipelines Act. You will also have the Section 32 of the Gas Act. All these are pieces of legislation that makes provision for expropriation of property. So now the question that I want to say is whether there is no need for an overarching legislation that will set out procedure that has to be followed, because you have these numerous pieces of legislation. The idea is for consistency. Then the second one will be it's a proposal to the current version of the bill, because it does not make a provision for a counter offer in case there is a dispute around after the notice of intention to expropriate was served. So what is your view in relation to inserting a provision that allows agreement to be reached between the parties based on a counter offer in response to a notice of intention to expropriate? That is the question that I want to pose to you.
May I respond, Honourable Chair?
Yes, Dom.
So first of all, yes, you've mentioned various statutes which have expropriation provisions within, and asked, is there not a need for a uniform law so that all expropriations proceed essentially in the same way? And we do understand and we endorse that need, which is why I did say at the beginning that we understand the need for a better expropriation statute in the country. But whatever we put in as an overall framework law must be in keeping with the Constitution. It must be minimally damaging to the Constitution, and it should have all the changes that I have suggested, which would help cure the defects in the current bill and bring it into line with the Constitution. So we're saying, yes, there should be a uniform law, but it should be one that's constitutional and that has the changes that we've outlined. And particularly important that we should change the definition of expropriation, that we should remove the nil compensation provisions, and that we should make sure that there is a prior court order before an expropriating authority proceeds with a disputed permanent expropriation. As I said, the bill recognizes the need for that, where it's a temporary expropriation or for an inspection. But a permanent expropriation is so serious for all concerned that there must be a prior court order there too. And that's no less than the Constitution requires. And then you asked about the possibility of a counter offer, that the notice of intention to expropriate would indicate what amount the expropriating authority has in mind. And you're suggesting that the affected owner should be able to put in a counter offer. That could be part of a process, but the most important thing is that if the dispute is not resolved, then the expropriating authority should have to go to court. It bears the onus of showing that what it proposes to do is fully in line with Section 25 and all other relevant sections of the Constitution. And once it has a court order confirming that what it proposes to do is fully in line with the Constitution, and that court will then also decide on what the compensation should be, as just and equitable in all the circumstances, then at that point it can issue a notice of expropriation to which it would attach a copy of the court order. So there will be no further dispute to be resolved, that any dispute will have been resolved already before the expropriation proceeds.
And to make a follow, but I see Tim has his hand up. Honourable Brotherson.
Thank you, Chairperson. I was just waiting for your inquiries to be dealt with. Chairperson, thank you. Is it Dr. Jeffrey?
Yes, it is, but Anthea is fine.
Thank you, Anthea. Anthea, could you just address us on two issues? The first is the difficulty around the clause, the reference to public interest, because expropriation bills around the world always refer to public good, and the addition of public interest now makes it a very subjective exercise as to what public interest is. And then secondly, the other issue I wanted to raise, which has now slipped my mind, will IRR consider constitutional court challenges to this bill if it's passed? That's a standard question I ask a lot of people. And then, Chairperson, my other question will come to me. Maybe if Dr. Jeffrey can just answer those first two. Thank you.
Yeah. Yes. Okay. But that probably before that, the court in the past has been accused of being too active in the arena of areas that falls within the competency of the legislative arm of government or the executive arm of government, to the extent that they have been accused of being an activist of some kind. And they've always said, look, it's always critical for the other two arms of the state to avoid drawing them into an arena that belongs to them. And the argument is there has to be clarity because of the manner in which the other two arms of state is located, it's positioned. The expertise that it possesses, the ability to conduct researches, the ability to utilize and maximize what it has at its disposal in terms of an army of skills and expertise, and they only come at a time when where there is a dispute around the transparency, around accountability, around whether there is no relationship between the decision that they took and the factors at hand. Don't you think that it's always important that the state or the executive arm of government or the legislative arm of government must be able to provide clarity on certain issues to avoid dragging the court into areas of being accused of legislating from the bench? Over to you.
Sorry, Chairperson, I've recalled my second question. Maybe I could just get that in and then Anthea can respond. Chairperson, the question is simply about and this is a very practical issue, Dr. Jeffrey, is around the David and Goliath scenario that we can sometimes create with legislation. The David here being the individual property owner and the Goliath being the state. Could you just give us your comments on, is there any protection or is there any cover from an individual property owner who may possibly be an asset-rich person but maybe a cash-poor person, and the resources they might have to fight off a challenge, an expropriation challenge by the state? The state obviously has, well, hopefully not infinite resources, but pretty much close to, versus a individual property holder who may not have the resources to challenge a matter in court, and whether there's any protection whatsoever in the bill that assists the individual property owner if they're placed in such a precarious situation. Thank you.
Over to you, Doc.
Thank you. Let me go through the questions one by one, if I may. The first was dealing with the matter of public interest. Absolutely, most expropriation laws in different countries allow expropriation for public purposes, for the building of a road or a dam, or to put up an ESCOM pylon, that sort of thing. But we allow, in terms of the Constitution, expropriation in the public interest But that is very much in the context of land reform and access to natural resources. And this bill does extend to property that is of a very different nature. So insofar as we have a definition of public interest, that wider public interest consideration can only come into play where the property that is being expropriated is linked to land reform and greater access to natural resources. So we couldn't apply the wider public interest argument where property of a very different kind, such as intellectual property, is being expropriated. There, I think one would have to be able to show that this is for public purposes. And we have in our submission suggested that the definition of public interest should be changed accordingly to make it clear that that wide definition can only apply in a land and natural resources context. You also asked about whether we'd go to the Constitutional Court. I'm not sure about it. We've certainly are deeply concerned about the damage that this expropriation bill will do at a time when the economy is reeling, when unemployment is so high, when we so urgently need to get growth, which I think the finance minister is also indicating as our best response to the predicament in which we find ourselves. So the expropriation bill could make it so difficult to achieve these important objectives that it may be therefore we will go, but I don't have a final decision on that. Then I think, if I understand you correctly, Honourable Chair, your concern is something about how the executive has skills and resources available to it. Perhaps, if I understood you correctly, you were indicating that you're not sure about this idea of the expropriating authority having to go to court to get a confirmation that what it proposes to do is constitutional. And I would like to answer that justly with a reminder of what the Constitution says, that this is the document that was adopted in 1996. And it sets out very clearly what the obligations on all branches of government are. And when it comes to an expropriation, the bill must provide for a prior court order. It does so in circumstances which are important, but not as important as a permanent expropriation. It says that you can't just send an inspector onto land if the owner doesn't agree. You must get a court order before the inspection can proceed. It says that if you want to extend a temporary expropriation from 12 to 18 months, you must have a prior court order. And the same must apply where there's a disputed permanent expropriation. The Constitutional Court or whatever other court is involved must have decided that the Constitution, that the proposed expropriation is indeed valid, that it either is for public purposes or it's in the public interest within the limited context where that applies. And it must have found that the amount of compensation and the time and manner of its payment must have been decided on a basis which meets the need for just and equitable compensation and for an equitable balance between the nation's interest in land reform and the interests of the affected owner. Because it's not fair to put the huge burden of redressing past societal wrongs on the shoulders of particular individuals. That's why the Constitution talks about the need for that equitable balance, so that the public interest in land reform can be weighed against the needs and the interests of the expropriated owner, who is not personally responsible for the past wrongs.
Thank you, Doc.
And what we need to do to stick to the Constitution is to ask for a prior court order, and then everything will be confirmed before the expropriation proceeds. And then the David and Goliath thing, I think that is the essence of it. Somebody like Becky Dlamini was David up against the Goliath, and he should have received a notice of expropriation that was claimed that it was served on him, but he never got it. And under this bill, that will very often be a problem. If service can take place by a registered post, for example, and we know the post office is in complete disarray, it may very often be the case that people in the situation of Becky Dlamini have no idea that they've actually been served with a notice of expropriation. We must make sure that the rules are fair to the small person against the massive power of the state. That's what common law has tried to achieve. That's what the Constitution strengthens in its rules on what must be done. And it's absolutely vital that the legislation passed by our Parliament should comply with the Constitution.
Thank you. I've seen two hands, Honorable Dango and Honorable Khai.
Chairperson, I think it's raised a question that has been bothering me for some time. Are we developing in South Africa an activist court that extends its own judicial kind of system as they did in the US? And in the US, judges are appointed to whether they Democratic or Republican, whether they're right or left. Are we developing the same kind of system here with the courts at this particular point in time? Or is that something that we should watch against and guard against? And that's the question for Dr. Jeffrey. Thank you very much.
Thank you, Honorable Dango. Honorable Khai.
Thank you very much again, Honorable Chairperson. Chair, ours is to listen to what the stakeholders are saying. It's not to argue with them. We listen to what they say, whether we agree with them or we don't agree with them. There will be time when we deliberate, where we consider the inputs of the stakeholders and the responses of the department, and decide what makes sense to what the stakeholders said and what the department has said and what the provinces in their negotiating mandate have said. But I was reluctant to do this. Doctor keeps on raising this issue of a prior court order. I didn't want initially to raise that. Yeah, I think it's a misinterpretation of the Constitution, because the Constitution says property may be expropriated only in terms of the law of general application for a public purpose or in the public interest, and subject to compensation, the amount of which and the time and manner of payment of which have either been agreed to by those affected. There's not the issue of a prior a court decision. A court decision can only happen when the court has to decide if those affected have not agreed on the issue of compensation. So this point that expropriation can only take place after the court order has been sought. I don't think it's a correct interpretation of the law, because parties can agree. Those who are affected could agree without necessarily going to court. So I don't think it's a correct interpretation of what that a particular section says. Thank you very much. But as I say, we do not want to argue with the stakeholders. We will have time to deliberate on our own as members on the submission of stakeholders, the responses of the department, the negotiating mandates from the provinces. For now, we just listen, not necessarily that we agree or we disagree with what they say. Thank you so much.
Thank you, Honorable Khai. I'm also looking at the time. Thank you for those inputs. Just last word, Dr. Jeffrey.
Thank you very much. I'll try and be very brief. We don't need to have activists' courts to apply what the Constitution says and what carefully drawn legislation says that is in line with the Constitution. And we should also, of course, recognize that expropriation should always be a matter of last resort. So it's not as if the courts are necessarily going to be bound up with disputes of this kind all the time. But where an expropriating authority cannot reach an agreement with an owner and wants to proceed with an expropriation, the onus lies on it to satisfy the court that what it proposes to do is in line with the Constitution. Otherwise, the guaranteed right means almost nothing. And it must also be able to have a court decision on the amount, timing, and manner of compensation. Because if I may just read the rest of the clause to which Honourable Khai referred, it said that the amount of compensation and the time and manner of payment must either have been agreed or decided by a court, must have been by the time the expropriation proceeds. So, of course, if there's agreement, then that's the end of a dispute. But if there's no agreement, then the amount of compensation and the time and manner of its payment must have been decided by a court before an expropriation can proceed. And that just confirms the need for a prior court order. This is the appropriate safeguard. This is the way to strike an equitable balance between the competing interests that are in view. This is the way to make sure that what is done is not unconstitutional. And I think that was it. I think I've covered the main points.
Yes, Doc, you have indeed responded to all the questions and clarity-seeking issues that were canvassed. Again, on behalf of the Select Committee, let me express our appreciation for honoring our invite to participate in today's public hearing. Thank you. Have a wonderful day.
Thank you, Honourable Chair, and to all the members of the committee.
Thank you, Doc. Honourable members, our next presenter will be Ms. Tyler Dallas from the FW de Klerk Foundation.
Yes, good morning. Thank you, Chair.
Thank you, Ms. Dallas. You are aware that you have 15 minutes?
Yes.
You can do 10 minutes. We'll greatly appreciate that because we have your presentation, went through your presentation with one point of emphasis. Thank you.
Can you see my slides, just to confirm?
Yes, that can be confirmed.
Great, thank you. Good morning, Chair, members of the committee and fellow stakeholders. I'm Tyler Dallas and I'm the Manager of Constitutional Programs at the FW de Klerk Foundation. I'm joined today by Dave Stewart, Chairperson of the Foundation, who will help answer any question members may have after the presentation. The FW de Klerk Foundation is a non-profit organization dedicated to upholding the Constitution and promoting the values, rights, and principles enshrined in the Constitution. The impact of the bill on property rights as contained in Section 25 of the Constitution and the rule of law under Section 1, subsection C is cause for concern, and so we welcome the opportunity to make submissions on the bill. We do want to note that the short time limit given today prevents us from engaging meaningfully with this committee on the substantive issues we've raised in our submission, but we will do our best to stick within the 15-minute time allocation. At the outset, we wish to state that we support land reform that is constitutionally compliant, that is just and equitable, and that has either been agreed by those affected or decided or approved by an impartial court. We strongly recommend closer cooperation between government and organized agriculture to achieve such an outcome. Secure property rights are an essential requirement for a free and prosperous society. Our Constitution is clear. No law may permit arbitrary deprivation of property. Herein lies a very clear constitutional obligation: expand property rights and protect property rights. Any attempt to dilute the property rights of citizens on the basis of race would erode the rights to human dignity, equality, non-racialism, and protection under the rule of law. The Foundation's submission focuses on the arbitrary nature of the deprivation of property envisaged in the bill and on the absence of proper definitions of the concepts of public purpose, land reform, and public interest. It illustrates the impact the bill will have on the well-being and freedom of South Africans, on national unity, the agricultural sector, investment, and economic growth, which we will cover today. Although South Africa needs a new Expropriation Act in line with Section 25 of the Constitution, we believe the present bill, incorporating as it does the principle of expropriation without compensation, would have catastrophic consequences for the property rights of all South Africans, for the agricultural sector and food security, for investment and economic growth, for national unity, and the future prosperity and freedom of all South Africans. In short, we are concerned that if the bill is adopted in its present form, South Africa might well follow the path of countries like Venezuela and Zimbabwe that have also abandoned property rights. The Foundation believes that the bill does not comply with the requirements of the rule of law in Section 1, subsection C of the Constitution because it lacks clarity insofar as there are no proper definitions for key concepts of public interest, public purpose, and land reform. There can be no proper public consultation process without clarity on these concepts. The definition of expropriation is vague insofar as compulsory acquisition might be interpreted to imply that the expropriating authority might acquire custodianship rather than ownership of an expropriated property, and then no compensation might be payable. The inclusion of the words including but not limited to in the circumstances under which no compensation might be paid is impermissibly open-ended and vague. The bill does not pass the Section 36 limitations test. There are many other approaches to land reform that would not have the very negative consequences implicit in this bill. The Property Clause, Section 25, was one of the most closely contested and negotiated provisions in the 1996 Constitution. The negotiating parties agreed to a delicate balance between the need to protect reasonable property rights on the one hand and the need for expropriation to achieve land reform on the other. The agreement required payment of compensation for expropriated property that would have to be agreed to by those affected or decided or approved by a court, and that such compensation would have to be just and equitable, reflecting an equitable balance between the public interest and the interests of those affected, taking a number of factors into account. The bill and the principle of expropriation without compensation would remove the keystone of South Africa's great national accord and would seriously undermine prospects of national unity. The application of expropriation without compensation would have a devastating impact on property owners deprived of property that might have been owned by their families for generations and that might be their only source of income. It would cause bitterness and irreparable harm to national unity, which we will now expand on. Government has continuously qualified its support for expropriation without compensation by insisting that it should not undermine future investment in the economy or damage agricultural production and food security or cause harm to other sectors of the economy. However, we submit this is a contradiction because of the negative impact of the bill that the bill will have on national unity, the agricultural sector, investment, and economic growth. One of the goals in the preamble to the Constitution is to improve the quality of life of all citizens and free the potential of each person. It is clear from any objective analysis that economic freedom based on property rights is a central requirement for the achievement of this goal. According to the Simon Fraser Institute Annual Economic Freedom Survey for 2022, there is an absolute correlation between economic freedom, of which property rights are a core and essential part, and virtually all positive social outcomes as seen in the graph here. These include GDP per capita, life expectancy, infant mortality, and differ based on which freedom index each country places from least to most free. The preamble to the Constitution also calls for a democratic and open society based on democratic values, social justice, and fundamental human rights. Human freedoms are one of the foundational values in Section 1 of the Constitution. Once again, there is a close correlation between free and democratic societies and respect for property rights, as is evident from the following table by Freedom House. The correlation between property rights and freedom should come as no surprise. Government would enjoy immense power over tenants in a situation in which all land and all homes would in effect be leased from the state. Possession of property empowers individuals to make their own life choices, to start businesses, to assist with the education of their children, and to provide security for their old age. It is one of the most important sources of human empowerment and independence, particularly with regard to the individual's relationship with the state. The collapse of property rights in Venezuela and Zimbabwe was directly related to the collapse of political freedom and prosperity in both countries. South Africa is not a rich agricultural country, with only 13% of its territory being suitable for arable production. Despite this, South Africa's commercial farmers, aging and rapidly diminishing, are widely regarded as among the best in the world and produce 95% of our food. The Expropriation Bill could have a devastating impact on the continuing ability of the remaining commercial farmers to produce the food on which South Africa depends. Government's current land reform model, in the form of this bill, flies in the face of all current experience gleaned from Zimbabwe and Venezuela and jeopardizes the 332.8 billion rand produced by the sector in 2017. This accounts for 2.6% of GDP. The bill would have a catastrophic impact on the agricultural sector, on its contribution to the economy, on the 808,000 people it employs, which is 5.5% of total jobs, and on food security. South Africa has thus far been regarded as one of the few food secure countries in Africa and has made good progress in improving food availability. According to Agri-SA, the farmland market is active, with 2% of total farmland with private title deeds traded annually. Notably, about 2 million hectares of farmland, 2.3% of total freehold farmland, has been acquired by Black farmers without assistance from state-sponsored land redistribution programs. They note further that taking account all pillars of the land reform programs, 24% of all farmlands have been redistributed or land rights restored. There has thus been some progress in this regard, negating further the need for such a catastrophic bill. The rights of South Africans, both across the spectrum and particularly human dignity, equality, and socio-economic rights, are negatively affected by South Africa's very poor performance in a number of key areas, indicated by economic growth of only 9.7% in the decade between 2012 and 2021, compared with a population growth of 15%. We have the world's highest unemployment rate of 34.5% and 45.5% expanded, compared to the global rate of 5.7%. We have the world's highest level of inequality, with 60% of households dependent on government transfers. Property rights are the foundation of all free economies. South Africa's current economic crisis and its failure to attract investment will inevitably be compounded by the adoption of the bill and the threat of expropriation without compensation. Sustained and inclusive economic growth is the only way out of crippling unemployment and poverty in the country. However, we will not achieve this if government continues with the adoption of the bill and the implementation of the principle of expropriation without compensation. The catastrophic example of countries that have set out to destroy property rights are there for all to see in Venezuela and Zimbabwe. Between 2013 and 2019, the Venezuelan economy shrunk by 62% and hyperinflation reached 10 million%. 3.4 million Zimbabweans and 5 million Venezuelans have fled their countries to escape poverty and repression. The difference is that should South Africa follow their example, there will be no borders across which its people will be able to escape. We submit the expropriation bill as it currently stands should be scrapped in its entirety, as it not only fails to provide an appropriate framework for expropriation, but is irreconcilable with the values that underlie the Constitution and would have very negative consequences for all the people of South Africa. We suggest withdrawing the bill and replacing it with a bill that is constitutionally compliant and that will not threaten the property rights of all South Africans. Government, working with Parliament and relevant stakeholders from the banking, agricultural, and public sector, should look for ways to create enabling legislation to speed up land reform in the country within the clear framework of Section 25 of the Constitution. Secondly, we believe the time and resources spent on this legislative endeavour could be better allocated to supporting and prioritising activities to expand property rights, especially by issuing title deeds to the 9 million plus households who own their own homes without title deeds. In this regard, we must commend the Free Market Foundation for its Kaya Lama title deed program, which has extended property rights to council tenants across South Africa by transferring some 10,000 title deeds at a cost of 2,950 rand, 3,000 of which took place in 2022, showing it is possible to extend property rights quickly if resources and energy are applied. Similarly, we note a number of policies and strategies run by the Department of Agriculture, Land Reform and Rural Development that have failed to perform. According to Amy Barkley of Agri-SA, the challenges experienced by the department can be addressed through a dedicated effort to address constraints in a collective manner, mobilizing public and private sector resources. She notes that the department must be allocated more finance for land to be purchased for redistribution. Currently, out of the 2.4 trillion rand allocated to economic development in the national budget, the department only receives around 17 billion rand to accomplish the mammoth task of land reform, which is simply insufficient to make a substantial difference to land reform and restitution. Finally, we submit that many lessons can be gleaned from the experiences of other countries who have similarly dealt with land reform and unlocking dead capital. The success in Peruvian land reform to unlock the wealth in the property of the poor provides a blueprint on how to unlock land capital whilst enabling land ownership in the country. According to Hernando de Soto, world-renowned Peruvian economist, a buy-in from the whole society is crucial to any land reform programs. Peru's Land Title Initiative program concluded in 2004 with 1.4 million households being registered and 920,000 land titles being provided. Similarly, the Venezuelan experience of the erosion of property rights provides an equally important comparative to what would happen in South Africa if the bill was implemented as envisaged. The Venezuelan economy had shrunk by 75% since its socialist revolution, and 7 million Venezuelans had left the country, losing 2/3 of its productive capacity. According to Professor Fernando Spirito, professor of public politics at the Catholic University in Venezuela, the Venezuelan case shows that the rules in place matter. The policies are important if we want to achieve a collective goal such as economic growth. The challenge is to find a way in which everybody, especially the government, respects the rules of democracy. In closing, we believe the bill would severely limit the rights to property of all South Africans, a core right that is internationally recognized, that is a requirement for free and prosperous societies, and that is essential for the empowerment and the realization of the potential of citizens. Simply put, one cannot have a free and successful society without secure property rights. The bill is unconstitutional insofar as it would facilitate the arbitrary deprivation of property because it does not meet the requirements in Section 36 of the Constitution, and it is irreconcilable with an understanding of the term public interest distilled from the Constitution and its founding values, particularly with regard to the negative impact it would have on national unity and possible irreparable harm to agriculture, food security, economic growth, and job creation. The Constitution is the instrument on which our new democratic society was founded. We believe the adoption of the Expropriation Bill might represent the point in the history of post-1990 South Africa at which the country turns decisively away from this great constitutional accord. I thank you for the opportunity to present and close for any questions.
Ms. Taylor, for taking us through the presentation from the FW Declare Foundation. Any clarification questions? I've noticed Honorable Dango. Ambassador, what is yours? I hope that is not a legacy hand. It looks like you were quite clear. Just from your side, just one aspect that I've constantly been raising with other candidates. In the current version of the bill, after receiving the notice of intention to expropriate, the recipient must decide whether he or she accepts or disputes. If the amount of compensation is disputed, the person cannot make a counter offer, and instead there is a provision for the dispute resolution to be applied, and the parties must either mediate or go to court. So what is your view if there is an insertion of a provision that allows agreement to be reached between the parties based on a counter offer? in response to a notice of intention to expropriate.
Thank you, Chair. So our direction would be towards Section 25 of the Constitution, which already does provide that there needs to be agreement between the affected parties. So there would need to be some type of agreement reached, whether that be through a mediation or through a court of law. And if agreement cannot be reached, then an impartial court would need to weigh in on that decision. I will pass to Dave Stewart, Chairperson of the F.W. de Klerk Foundation, to also answer that question.
Okay. Chairperson.
Mr. Chair, yes. The idea is that there must be an equitable balance between the interest of the state in expropriation for the purpose of land reform and the very valid interest of property holders. And this is the whole purpose of Section 25. Either there must be an agreement between the state and the person to be expropriated, or there must be a proper court order determining what the court, an impartial court, believes is equitable compensation for the party to be expropriated. And that is the way we believe it should be. If the state takes over the ownership of the property before compensation is paid, then the property owner is in an impossible position, often without resources to fight expensive cases against the state and the courts, faced with the possibility of having to pay the legal costs involved. That would not be equitable, and that would be against the whole sense of Section 25.
Thank you, Chair. Just maybe addition as a follow-up. Look, currently there are a number of legislation that are in existence which grant the state power to expropriate, except that there's not been any revision to the current overarching Expropriation Act of 1975. And as a result thereof, the procedure that has to be followed in terms of this overarching legislation is non-existent. You'll remember that extension of Security of Tenure Act, Section 26, Section 38 of the Criminal Land Rights Act, Petroleum Pipelines Act, the Gas Act, all this act to a larger degree grant the power to expropriate. So I guess you therefore will agree that there is a need to consolidate the procedure under an overarching legislation that will ensure that there is consistency in terms of how expropriation must be undertaken.
Honorable Chair, we agree 100% that we need a new Expropriation Act to be compliant with Section 25. But then the key element is that it must be compliant with the letter and the spirit of Section 25, so that when compensation is necessary, and it should be the option of last resort. When compensation is necessary for expropriation, it must be in letter and in spirit equitable and fair to all of the parties. We need land reform. We've got no problem with the idea and concept of land reform. There's more than enough land in South Africa to achieve the purposes of land reform. But we need a definition of land reform. Does it mean that all of the land goes into the possession of the state and that the beneficiaries are tenants? Or does it mean that we have a whole new generation of farmers who own their own property? History throughout the world has shown that if you have the latter option, it empowers the whole of our society. Everybody gains. We have food security, we have national unity, and it's fairness for all. but then we must stick to the letter and spirit of Section 25.
Thank you, Chairperson, and also to Ms. Taylor Dallas for honoring our invite to express and communicate the views of the Foundation in relation to the current bill that is the subject matter of consultation. And I guess the committee appreciate your manner of expression. And on that note, have a wonderful day. As you
Thank you,
continue.
Honourable Chair.
Thank you.
Thank you, Chairperson. Thank you, Ms. Taylor Dallas. Honourable members, we have the following institutions that are still standing. We have the Mineral Council of South Africa, we have the National Empowerment Association of South Africa, we have COSATU, we have the Banking Association of South Africa. We want to propose that we just break for 10 minutes if members are happy with that, so that we are then able to take just to refresh, and then thereafter we'll then take all. My proposal is that we take all the presentations, and that when members have questions, let them note them, and then after all the presentations are made, then we get 30 questions, because we're only left with 4 now. Thank you, honourable members. Let's just break for 10 minutes. Thanks. Are members back?
Present, Chair.
Thank you, thank you. Less than probably I see other members are still logging in. Maybe let's wait until 20 past, then we start.
Present as well, thank you.
Thank you, Honorable Sonia.
I'm present.
Present as well.
Thank you.
Yeah,
Then I
present.
think, thank you. Then I think let's start there. The proposal that I came with is that let's take all the presentations and then members must then note questions that they have in relation to the presentation, and then once all of them will have taken them, then we'll then probably individually engage them. I think that will save us a bit of time, so that at least by 1 o'clock we're done. As I said, the next presentation now will be from the Mineral Council of South Africa, which will be led by Mrs. Brown. If Mrs. Brown is, no, we had set. I see we have set time for 11:30. But if she is available, we can start. Let's just check that.
Good morning, Honourable Chair. Good morning, Honourable Members. I am here.
Oh, great. Then you at least you'll save us time. Let's hit the ground running. You're welcome.
Thank you, Chair. I'm just trying to share my presentation. I just want to check if it is visible on your side.
It is visible, Ms. Brown.
Just go to slide share. Apologies for that, Chair. Again, good morning, and thank you so much for the opportunity to make presentations on this very important bill. Chair, from a Minerals Council perspective, who we are, we a mining industry body representing the mining companies producing about 90% of South Africa's mineral production and employing about 90% of the employees employed in the mining sector. Our principal objective is to advocate for major policy positions which are endorsed by the mining industry, and it is in this capacity, Chair, that we're making the presentation today. Chair, I think a lot has been said about the constitutionality of the bill, and without running the risk of repeating what has been said, our key concern, Chair, is that the bill was tabled in Parliament against the backdrop of the Constitutional 18 Amendment Bill, which we are all aware of has been rejected by Parliament and is not being proceeded with. Notwithstanding that, Chair, we note that the preamble of the bill, as well as various provisions in Section 12, specifically clauses 12, 3 and 4, still relies on the expropriation without compensation notion, and also provide for circumstances when no compensation can be allowed. We are of the firm view, Chair, that this is putting the cart before the horse, and it renders the bill subject to constitutional challenges, and we will also elaborate further on that. Specifically in relation to the determination of the compensation as provided for in clause 12 of the bill, it only refers, Chair, to the amount of compensation which must be just and equitable. It does not include a reference to the time and manner of payment, which must also be just and equitable. And it is our firm view that this is misaligned to Section 25 2B and 3, which not only requires the amount of compensation, but also the time and manner of payment to be just and equitable. There's also various provisions in chapters 5 and 6 of the bill which seeks to determine or confer on the expropriating authority or someone else, such as an arbitrator or mediator, a power to determine the amount of compensation. Again, this is clearly misaligned to Section 2B of the Constitution, and I think this clause was earlier read out by one of the parliamentary members. Section 25 to be clearly makes it abundantly clear that the amount of compensation and the payment thereof must either be agreed to by those affected or decided and approved by a court. So it is not incumbent upon anyone else to make a determination on the amount of compensation payable in our view. Section 12.3 and 4 provides for various circumstances where land can be expropriated for no compensation. We are of the view, Chair, that Section 25 specifically does not provide for any circumstances where no compensation is payable, and hence the bill in this regard contravenes Section 25 2B, in that it constitutes an interpretation which is much wider than the founding provisions of Sections 25 2B and 3 of the Constitution. We also note, Chair, that it is the function of the judiciary and not the legislator to decide whether property may be expropriated without compensation. Those affected by the decision do not agree with the decision. And this is specifically in light of Section 25, subsection 2B, which affords that power to the judiciary. What Section 12.3 and 4 therefore does, it seeks to usurp the powers expressly afforded to the judiciary, and in doing so, we are of the firm view that it offends against the doctrine of separation of powers, which is part of the rule of law, as set out in the principle of legality in Section 1C of the Constitution. The Minister, in tabling Clause 12 of the bill, is therefore asking Parliament to invade in what in the Constitution is the preserve of the judiciary, and thereby offend against the separation of powers between legislature and judiciary. Coming then to the 5 circumstances calling for no compensation in clauses 12.3 and 12.4. Chair, it's not clear why these circumstances specifically has been identified to call for no compensation. No guidance is given to a court as to how these factors should be considered. Specifically in relation to clause 12.3a, we also have the view, that this specific clause seems to discriminate against landowners whose sole purpose it is to speculate in land, and we are concerned, Chair, that this again might render the bill subject to a constitutional challenge, specifically contravening equality provisions in Section 9 of the Constitution, as well as the right to freedom of trade, occupation and profession as enshrined in Section 22 of the Constitution. With regard to clause 3.1c, which includes no compensation in relation to land that has been abandoned, we believe this is clearly unnecessary because abandoned land by operation of law accrues to the state, so there's therefore no need to include that specific provision. What is very concerning to us, Chair, is the inclusion in relation to clause 12.3e, which deals with property that poses a health, safety, and physical risk. Our concern here, Chair, is that it might have significantly unintended consequences, specifically in the context of mining, because mining is by nature risky, and despite the best efforts of a mining right holder, mining does pose a health, safety, and physical risk. Having said that, mining properties are subject to stringent regulatory health and safety requirements as set out in the Mine Health and Safety Act. And we believe that the inclusion of this clause might have unintended consequences and therefore be inappropriate in relation to mining companies. It could be that the intention was to deal with these properties in relation to perhaps the hijacked properties, that we see in the city. But as I said, it could have a significant unintended risk from a mining perspective. With relation to the inclusion in clause 12.4 that envisages that land subject to a labor tenancy could be expropriated for no compensation. We also point out that this is in direct conflict with Section 2, subsection 2 of the Land Reform Act, which envisages equitable compensation for the landowner of the right. With regard to the mining specific issues that we have identified, Chair, these are specifically dealt with in sections 9(1)(b), Roman 2, which provides for the fact that all unregistered rights in property will be simultaneously expropriated on the date of expropriation, unless those rights, including permits or permissions, were granted or exist in terms of the MPRDA. On the one hand, Chair, I think this clause is a significant improvement to what was previously in the bill, and we're very grateful for the inclusion of the references to permits and permissions granted in terms of the MPRDA. But we just caution, Chair, that Clause 9(1)(b) still remains unclear, because the references to unregistered rights is rights rights which are defined as rights which do not require registration. And if you read this clause, it only refers to permits and permissions granted in terms of the MPRDA and not necessarily rights which were granted in terms of the MPRDA. This creates some ambiguity, and we would request, Chair, that this clause be amplified to not only refer to permits or permissions, but also include rights which were granted in terms of the MPRDA. In addition, Chair, we note that Clause 9(1)(b)(2) does not refer to historic mine dumps, which are not governed by the MPRDA. Historic mine dumps are those dumps for information that was created prior to the MPRDA coming into effect in 2004, and in respect of which mining is still being undertaken. We similarly request that Clause 9(1)(b) Roman 2 be amplified to additionally refer to historic mineral stockpiles and to historic residue dumps, which is currently not governed by the MPRDA, so that it is also covered by the exclusions set out in Clause 9(1)(b) Roman 2. In relation to Clause 9(1)(d) of the bill, which provides that the property remains subject to all registered rights in favor of third parties, with which the property was burdened with prior to expropriation, unless or until such registered rights are expropriated from the holder thereof. We're grateful again, Chair, for the inclusion of this provision. The only concern that we have is that rights granted in terms of the MPRDA sometimes take a significantly long time before it is registered. So until such time it is registered, it will not fall within the definition of unregistered right, nor will it fall within the definition of registered right, and hence it might there's a risk that it might not be covered by the provisions of Section 91B, Roman 2, nor Section 91D of this bill. We therefore request, Chair, that the provision clause 91D be amplified to also include all those rights, permits, or conditions which were granted or exist in terms of the provisions of the MPRDA. Lastly, Chair, sorry, not lastly, a further concern that we have is the issues that deals with the suspension of a decision set out in clause 19 of the bill. Clause 19, subsection 8, does not provides that any appeal against the decision of a court on the amount of compensation will not prevent the expropriating authority from expropriating for the amount approved or decided unless a court grants an interdict based on compelling prospects of success. The effect of this is that where you lodge an appeal against the decision of a court, it will not suspend that decision. The concern that we have is it goes against Section 18(1) of the Superior Courts Act, which provides that the operation and execution of a decision which is the subject of an application for leave to appeal is suspended pending the decision of the appeal. To the extent, Chair, that this provision is not changed, we would urge that it be amplified to provide for an adjustment, either upwards or downwards, specifically to cater for those circumstances where the appeal court comes to a decision which differs from the lower court. And then our last slide deals with the rights and obligations relating to the property after expropriation. What is missing in the bill, Chair, is it does not provide where the responsibility would lie for liabilities associated with the property after it has been expropriated. And we believe that it may give rise to various disputes, particularly as the former owner or occupier of that property would no longer benefit from the use and enjoyment of that property. In this regard, we also bring your attention to the provisions of Section 28 of the National Environment Management Act, which provides that every person who has caused or may significantly cause pollution or degradation of environment must take reasonable measures to prevent such pollution or degradation from occurring or continuing to occurring. In the absence of having clearly identified liability associated with expropriation, it might be difficult for the owner of property to comply with the provisions set out in Section 28 of NEMA. Specifically, if that person no longer has control over the property, might not be able to get access to the property and might be found guilty of trespassing if he attempts to do so without the consent of the new owner. We also believe, Chair, it's not neither just nor equitable to hold the former owner or occupier liable for residual liabilities in circumstances where the property has been expropriated. Likewise, the absence of a provision regulating residual liability may also, unduly expose a prospective owner who may be held accountable in circumstances where they did not cause the harm to the property. Chair, these are our submissions, and again, thank you very much for granting us the opportunity.
Thank you, Ms. Brown. We have received your presentation. We kindly request that you will be with us until we have taken all our presentation, because what we want to do is we want to take clarity-seeking questions after I've received all the presentation from the remaining three presenters.
Note, Chair. Thank you.
Thank you. Honourable members, we will now move to the next presentation, which will be done by National Employers Association of South Africa, led by Mr. Jay Swart. Mr. Swart, are you on the floor?
Yes, thank you, Chair. Thank you for the opportunity. Screen. My screen visible, shit.
Yes, there it is.
Thank you. Chair, thank you very much for the opportunity to make a presentation. Thank you to the members of the committee. Chair, I found myself in the fortunate or unfortunate position that most of the issues that we will be raising have already been raised by previous speakers. So unfortunately for the committee, a lot of this will be repetitive, but I will try and be as brief as possible. Chair, the National Employers Association of South Africa is an employers organization, and we represent business interests. As such, we believe it's incumbent upon us to comment on legislation and policies that have a negative effect on the business environment and consequently business. We have submitted comprehensive written submissions, which we will take as having been read. So therefore, we will only highlight a couple of issues which we believe are important. Yeah, I think it's common cause that the current Expropriation Act is not in line with the Constitution and needs to be updated. The principle of expropriation of property by government for a public purpose is well established in our law and is not disputed. However, the current Expropriation Bill, or in its current form, poses a number of dangers due to wide definitions and possible abuse that are open to interpretation. It goes far beyond the scope of the current Expropriation Act of expropriating property for a public purpose. So the main concerns with the bill, which we will address in the presentation going forward, is that landowners, farmers, property owners are concerned that this bill creates the opportunity for the state to expropriate private property, including land, at no compensation under the guise of land reform as an element of public interest. Our proposals, which we will motivate through the presentation, is to restrict the definition of property to their natural resources only, define or qualify in the bill itself that an active farm is a business and not land for purposes of the Act. Alternatively, remove land reform from public interest in the bill, or as an alternative, which is not the preferred alternative, clearly define land reform to exclude land redistribution for purpose of expropriation in the public interest, and of course remove the possibility of expropriation of privately owned land at no compensation. This would achieve security for farmers, private property owners, financial institutions, and of course secure our national food security. It will hopefully ensure the continuance of local and international investment. It will ensure the safety and stability of financial institutions and negate the possibility of land grabs and abuse of power in terms of the bill. Furthermore, it will allow fair and just expropriation for true public benefits. First issue we have is the definition of property. Now, the bill mirrors the definition of property as it is found in Section 25 of the Constitution. And in particular, Section 25(4)(b), which is problematic, which states that property is not limited to land. Within the context that the purpose of the bill is to address land reform and ensure equitable access to natural resources in order to redress past racial discriminatory laws and practices, we find it difficult to envisage a scenario where the state will be expropriating property other than land for purposes of land reform or to grant equitable access to natural resources. We cannot foresee a situation where that can happen. Therefore, we propose that land, if this bill should be used for land reform purposes, should be limited to land and natural resources only. Secondly, Chair, the whole issue around third-party rights of expropriated property. The bill does provide that where property is expropriated by the expropriating authority, that authority will also receive the third-party rights, with the exception of mortgage bonds. The bill stipulates that when the property is expropriated and ownership is transferred, that mortgage bond will be cancelled. And then the bill has a whole lot of provisions regarding how any compensation that is paid in respect of the expropriation should be paid to the mortgage holder. However, there's a real danger, particularly in the light of Section 12.3 of the Act, that the compensation offered will be far below market value, possibly even at no compensation, and will be far below the amount outstanding on the bond. This will, of course, make banks and financial institutions much more reluctant to extend mortgage bonds, to extend loans, to provide working capital and so forth, which will undermine agricultural production, food security, and the entire economy. Chair, this is also unfair to the expropriated owner, who must now pay an outstanding balance on a property he no longer owns. And if he does not receive proper compensation, he will also not be able to replace that property. We foresee that this will result in many defaults. The previous owners will simply not continue to pay the bonds, and this will in turn create a banking crisis and have serious ramifications for the financial institutions. Section 12 of the bill, Chair, which deals with compensation. Section 12.1, we have made some proposals. The additions in red is for consideration, and we have added F, which simply provides for consequential loss of the expropriated owner in order to basically start over. So it provides for direct loss, not only for the value of the property, but also the consequential loss thereof. It is difficult to understand why a clause is necessary which indicates which criteria or circumstances should not be taken into account when determining compensation, especially in light of the fact that Section 12.1, which states which criteria must be taken into account, is not a closed list. It's open. So any other criteria may be taken into account. It's our proposal that every expropriation must be done holistically. All the circumstances of each particular case must be taken into account when compensation is considered or is determined. So in terms of Section 12.2, we propose that it should be scrapped with the exception of 12.2c, which we believe can simply move to Section 12.1, and Section 12.2d, which also can move to Section 12.1. We believe these are matters has to be considered when compensation is to be determined. In terms of Section 12.2b, which deals with the special suitability or usefulness of the property, we do not see this as a compensation issue. Our view is that this is certainly a consideration that must be taken into account when the decision to expropriate or not is taken in the first instance, and not only in the compensation stage. Reason being that it would seem to be nonsensical for government to expropriate a property which is not suitable for the purpose it wants it to expropriate it for. Then it shouldn't be expropriated in the first place. Then in terms of clause 12.3, Chair, and this is probably the most controversial clause, which deals with circumstances where no compensation may be paid. First issue, Chair, is it's not a closed list, first of all. So it will allow the expropriating authority or the court to say, well, we can take into account any circumstances where no compensation may be paid. This is simply too vague, Chair. It is arbitrary, not in line with the rule of law, and simply unconstitutional. Section 25 of the Constitution does not allow for compensation or expropriation without compensation. In fact, it's a requirement that compensation must be paid. There's also no grounds to argue that subject to compensation in the Constitution can be read as no compensation. That is also why it was proposed to amend this particular section in the Constitution, which we all know has failed in Parliament. So it is unconstitutional, simply the whole section 12.3, and should be scrapped. But the issue, Chair, is that there's no definition of land reform in this bill. In fact, no legislation that deals with land issues seems to have a definition of land reform. It seems that there's a school of thought that land reform encompasses land restitution, security of tenure, as well as land redistribution. Now, we have no objection against land restitution, where its procedure is substantially fair and to make good past racial discriminatory laws and subject to compensation. Neither do we object to the security of tenure. However, if it is correct that land distribution is viewed as part of land reform, then it has no place in this bill, and the whole land reform issue should be removed from the bill, Chair. As previously mentioned, that the purpose of this bill should be to expropriate property for a public purpose, i.e. a dam, a road, or a power station, whatever the case might be, and not for purposes of land redistribution. In any event, legislation dealing with the restitution of land rights, which deals with land restitution, and the Security of Tenure Act, which deals with tenure. So there's no need for this act to deal with those issues. There's already legislation dealing with it. Therefore, Chair, we propose that the bill must be amended to allow for the expropriation of land and resources only, and this should be for a public purpose. Secondly, it links to the first one. There must, I beg your pardon, Chair, let me just go back to the first point. There must be an emphasis on government land, first of all. Secondly, Chair, where private land is expropriated, it can only be for a public purpose, i.e. the development of infrastructure to the benefit of the whole of the country. In every instance where the state takes lawful ownership of land, compensation must be paid. And the whole concept of no compensation should be scrapped. It is simply unconstitutional and a requirement of Section 25 of the Constitution. Those are our submissions, Chair. Thank you very much for the opportunity.
Thank you, Mr. Swart, for taking us through the presentation on behalf of FINEAS. Like as we have indicated, we will take all the remaining presentation and then thereafter engage with the presentation. We are left with 2 to go now after yours, so it won't be a very long wait. Let's then move to the next presentation. The next presentation will be led by Mr. Pats, Matthew Pats, on behalf of COSATU. Pats, are you ready?
Good morning, Honourable Chair. Good morning to members. Sorry, got to keep up with what time of the day it is. No, we're here, Chair. Yes, and thanks very much. It's good to see you in good health.
Great.
So I'll just quickly upload.
The floor is yours.
No, thanks very much, Chair. Yes, no, thanks, Chair, for giving us space as COSATU just to share our views on the Expropriation Bill with the honourable members and colleagues. We've been involved as COSATU with this Expropriation Bill, I guess it's about almost a decade now. We've been quite involved at NEDLAC on it, both of the current bill and also the previous bill, which was about 10 years ago. So look, it's an important issue for us. I think it's an important issue for the entire country. Our stance, Chair, that look, we support the bill as COSATU and our affiliates. But we think there's a need for calm debate. We think sometimes the aesthetics on all sides of the debate are not helpful. The issue of the legacies of apartheid, of colonialism, the issue of expropriation that people experienced during the apartheid era, more recently, the issue of inequality and poverty, of homelessness, of unemployment, and how they are all centrally linked to the color of one's skin and where one happens to be born. Those are sensitive issues, and I think at times when colleagues on all sides treat it like a political football doesn't help anyone. I think our stance, Chair, as COSATU, we support the bill. Our premise is based upon that South Africa, to our eternal shame as a nation, all of us, is that we remain the most unequal country in the world. That is a ticking time bomb. Chair, also, we support the Constitution. We think, Chair, our interpretation of the Constitution is that it obliges us quite explicitly to address the colonial and apartheid legacies. It also obliges the state. It requires the state to ensure equitable access to land as well. I think we all know the challenges we've experienced as a country since 1994 with regards to a land reform, that it really has not made the impact we would have needed to have made so for a variety of reasons, including the issues that this bill seeks to address. Chair, I think we also need to bear in mind that there's a real danger if we continue as is, if we don't address the issue of land reform. I think we can just simply look at Zimbabwe and many other countries who didn't deal with it decisively in a sustainable, systemic way, and then there was a consequence. I think, Chair, that as a sober organization, we think that we should not be comfortable with a law which was crafted in 1975, the height of the apartheid era. If memory serves me right, B.J. Foster was Prime Minister at that stage. And obviously, the Expropriation Act doesn't reflect the values of our 1996 Constitution. We're not rushing it. Just 29 years down the road into democracy, I think it's time to ensure the Act is in line with our Constitution. And all countries around the world have an Expropriation Act. So this is not an unusual thing. We think the bill is a rational intervention. And of course, Chair, it's also critical to have a single bill which provides clarity to everybody, to all levels of state, all municipalities, entities, etc., SOEs, and also to society at large. We think, Chair, on the specific debate, which obviously gets lots of attention on the nil compensation, we think there is a rationale for certain instances for nil or for partial compensation to be taken into account. I think, Chair, again, a step back is that we're dealing with still the legacy of apartheid colonialism. It's not a figment of our imagination. Millions of African and colored urban residents in rural areas, in cities, in Cape Town, etc., are forced to live in informal areas. They live in backyard dwellings across Cape Town, for example. Many people in rural areas, largely African, colored, and women, farm workers, and so on, don't have access to land just simply to build homes on, to grow food on, to live a life on. The same thing in the cities. People want land also to live on, not to be condemned to live in a backyard. If you look at the land ownership from Stats SA, it still remains overwhelmingly white and male dominated. And again, we can do nothing, and then Zimbabwe is our future. And I think all of us, all sober persons, would want to have a more sustainable approach to dealing with our issues. We think with all of the government's best efforts since 1994, overall, in terms of land ownership, we have failed to significantly eradicate the apartheid and colonial land ownership patterns. At the same time, I think partly why this bill came up about a decade ago, Chair, was that you remember the Mala Mala Game Reserve. I think that time that the budget allocation per annum for land reform was about, I think, 2.3 billion rand, something like that. And Mala Mala owners forced government to basically pay 800 million rand. It charged a third of the entire budget. So clearly there is an inadequate state budget for it. Chair, we also think it's important to take into account the morality or the lack thereof of compensating persons who receive land due to apartheid era expropriations. Your District 6, your Sophia Town, and many other parts of the country. There was no compensation paid to African or colored or Indian owners at that stage. And if there was, it was a minuscule 1 rand, 2 rand, etc. So do we really want to compensate persons who never paid for it in the first place? In terms of the administrative processes of the bill, we think it provides a fair set of processes for expropriation. It provides checks and balances despite the aesthetic attacks on it to prevent government abuse. It is not true to say that it is interfering with legal access to your constitutional right to courts. The bill is quite clear, and no bill can block anybody from accessing relief from the courts. The bill is clear, when and how will you access courts for relief to any party, including on the issue of compensation. But what it does is try to provide a sober set of timeframes so that you don't have processes taking 10 years, etc., etc. We think this issue is an important issue because despite the historical tax on the bill, the majority of expropriation actually involves workers' properties. So workers' homes, a teacher's home, for example, a worker in the private sector, when government wants to build a road, to expand a freeway, build a power station or dam. So most instances, actually, it's workers' property. So that's why we have a real vested interest on it to find a fair and a right balance. We think the bill does do that. We think it's correct that the bill limits timeframes involved to avoid cases just being excessively drawn out, thus blocking expropriation for public interest like land reform. And often it's done by owners simply to squeeze government to give them a better price. On the transformational provisions, we think that the provisions in providing for mandating expropriation where needed for public purpose, public interest, specifically land reform and institution, are fair and they're quite specific. It's not a blank check. We think they provide the correct redress for persons who lost property due to apartheid and colonial expropriations. We also support the provisions in the bill where it says the state has an obligation to ensure equitable access to natural resources, like mineral resources, water, land. And again, these are real ticking time bombs. We've seen huge conflicts around it, especially around water, which is going to increase. It also, Chair, is important because people who attack the bill fail to recognize we have many people who have unregistered rights. And for the first time, these rights and the needs of these unregistered right holders will be recognized. It also recognizes people whose land tenure still remains insecure because of the colonial and apartheid laws and practices. When it comes to the issue of determination of compensation, we think the bill provides a fair, rational balance, a constitutional one, where it takes into account how was a property acquired, what is its current usage, what is the purpose for its expropriation, what is the market value, what are the improvements done by the owner, by the state, what's the public interest. And that's a fair, useful guide to make sure that all of us have a tick list to hold the state accountable, to also hold people's rights in surety. And of course, Chair, since this time, there's been a recognition of the role for the valuer general. That also helps to provide a sober determination for the value of a property because at times it's been abused by owners. When it comes to, again, around determination of compensation, look, this is critical because it compels government and courts to include these factors when they deal with these cases. And, you know, for example, was the property acquired during forced removals in the apartheid era? What was the compensation paid that time? It takes into account what improvements has the owner made? And again, how will it benefit the public? So it's not just a blank check for abuse by the state, which is important. We think it's important that we have these specific criteria because it also helps it to simply being a question of the market value and ignoring broader societal needs and real issues. So we think also the bill provides for the expropriating authority and affected parties a process to table offers, to table counter offers, to seek consensus on compensation, to kind of guide it. It provides recourse for either party to seek relief from the courts in the event of a failure to find consensus. And it provides the right balance between the state administrative role and, of course, the role of the courts, which is to provide legal oversight and relief. The court should not be involved in the administrative issues. So we support ththese provisions as COSATU. Just getting towards the end, Chair. On nil compensation, look, we support the nil compensation provisions in the bill because they speak to the issue of advancing land reform, specifically with regards to idle, private or state land, abandoned land. We have many instances across the cities where people have simply abandoned property, which now the state can't do anything about it because it's not empowered to expropriate. And why should the state be hamstrung looking for somebody who's in Australia who has no interest and society needs this property? We think it also provides a fair balance to the state to protect the fiscus around land whose value has been inflated by state investments. And also, of course, when you deal with the issues of disaster management, the need for the state to intervene quickly around environmental, health, safety, and property, etc. So, Chair, in kind of getting to the end, we support the bill. We think it's going to help advance land reform, deal with the constitutional obligations to address the legacy of colonialism, of apartheid. We think it's not a magic wand, but we think it's going to significantly help to empower the state to utilize expropriation to accelerate land reform. We think it provides clarity for everybody around compensation, whether it's full or partial or nil, and what circumstances. Society can hold the state accountable for land reform because it provides a clear set of processes and tools. It provides a fair protection for workers and ordinary people's property from abuse, etc. Provides very clear checks and balances and timeframes and legal recourse for all parties who are aggrieved. We think, Chair, the opposition to the bill is not fair. It's hysterical, often is not factual. We think many people are actually seeking to preserve the legacy of a colonialism and apartheid. And we actually need rational debate. We don't need historical slogans. Delaying land reform is a ticking time bomb, and we've seen the consequences of countries which failed to do that. We think there's a failure to understand the need to protect rights of ordinary workers whose rights are often abused by corrupt officials in collusion with the private sector. And we think the bill does help prevent abuses in the future and provides the right balance to protect workers, capacity in the state, accelerate economic growth, and job creation. So in conclusion, Chair, as COSATU and our affiliates, we support the expropriation bill. We believe, we're convinced, and I think many legal people have said clearly that it is constitutional, it's in line with international norms. We think it's fair, it's rational, it's an equitable compromise. It is going to help empower the state and compel it to do more around land reform, but also provides a fair protection for other parties too. So we believe Parliament should pass it. We'd want to see it being passed within this term. And of course, Chair, lastly, it will go to the Constitutional Court. We have no doubt about that. Those who are aggrieved by it will take it. That's their right. But we're convinced, Chair, that this bill will pass constitutional muster because the Constitution, as much as it says yes about the issue of compensation, it also says quite eloquently there's a need to address the legacy of apartheid and inequality and to show equitable access to land, etc. And this is a fair and as a rational compromise. And I think, Chair, it's quite telling that those who are opposed to it have yet to provide a single fair compromise to it. All they have done is to seek to obstruct progress and transformation, and that would be the detriment to the entire society. So I think, Chair, for our side, we're happy with the bill. We urge Parliament to pass it, and we support it fully as COSATU. I hope I've stuck to my time frame, Chair. I might have exceeded it by 1 minute, and apologies for that. Thanks, Chair.
Thank you, Mr. Parks, for taking advantage of the platform created by this process to put across the views of COSATU, views of the workers as it relates to this bill. As we have pointed out, we will engage with the presentation after the last one. The last presentation, which will be led by the Banking Association of South Africa, Mrs. B. Kunene. Are you on the platform, Mrs. Kunene?
Hi, good day, Chair. I'm Mr. Dlamini, standing in for...
Dlamini.
Yes, thank you. We really wanted to make it here. She even traveled to Cape Town, but we were told that this is strictly virtual. So she's in another meeting, but we have her support and delegation to actually do this work. And with me, I have my colleagues on the line, Mosidi Malamu, and I've got Dr. Chaman Shilwane. I also have Mr. Dupree from Nedbank. So we'll be responding a bit later, but I'm leading the presentation if I'm allowed to do that. And just before I start, may I take this opportunity, sir, to say thank you very much. Banking Association is really, really grateful for this opportunity that you are giving us to share what our anxieties are, and also to appreciate the goodwill from the government side in actually taking us seriously and our input into working towards this bill. We really, really appreciate that. And I don't know, say, if I may proceed, because I don't know when are you starting with my 15 minutes?
The floor is yours, Mr. Dlamini. You have 15 minutes to present now.
Thank you, sir. My colleague, Mosidi Malamu, will be projecting my presentation, from which
yes, I will. If I could be given sharing rights. Good afternoon, everybody.
Good afternoon, Ms. Mosidi. Can you help Committee Secretary?
Sorted, Chair.
Thank you. Over to you, Ms. Musiri.
Yeah, while she's projecting, may I take the time to introduce Banking Association to the committee? If you can put it on a presentation mode as well. Yeah. Thank you. Yeah. Just to remind the committee that Banking Association will represent all banks interested in South Africa, both locally and internationally, that are banking operating in South Africa. We've got approximately about 36 members that we represent. So this is a big responsibility, and therefore you'll see the response that's being presented here is a culmination of deliberations from all the banks through the Banking Association. So having said that, we actually are cognizant of the land ownership patterns or property ownership patterns in South Africa, and there might be a need really for certain adjustment that the government needs to do to actually enhance living standards in South Africa. And BASA is committed to supporting land reform. We're not taking this bill as land reform, but it does have some aspect of it that overlap. We're cognizant of what the land reform really has been meant to deal with. And we are highlighting this because there's a lot of good work that was done in that act, and that can actually help to build into this bill that we're working on. Next slide, please. Next slide, please. All right. So the next slide, we'll be talking about basically financial sustainability impact of the bill. Most of the previous speakers have spoken about the dangers, and please just maybe it is important when you look at the inputs from all members, including ours, that there is no total opposition against the bill itself, but we're saying that there are particular aspects of the bill that really need attention and careful consideration. And as a bill, it's easy to confuse practices that are required, implementation, practices that will be proposed post a promulgation of the Act itself. So please bear with many of us that we have that anxiety, but we also trust that the government has good intentions to do the right things for the country. So if you look at the banking sector, we rely a lot in terms of lending credit, making money through lending money to business. We look at property in many cases in its various forms, corporeal and incorporeal, to lend that security for the money that we expend. And but the challenge is that when that security condition is threatened somewhat, it will have a serious impact on how we do business and how we support the economy. So it's important that we look at that quite carefully. Having said that, the biggest concern is the compensation. How is it going to be determined? And many colleagues before have actually spoken about that. But let me just bring the financial aspect of it, that when the compensation on affected properties is below what we call market value, there will be a challenge, a serious burden both to the current owner of the property and the bondholders, which is the banks. that must be managed carefully. We are saying for government, it's important when there's a difference between the two. There must be a mechanism for guaranteeing the gap in between. And just to go back, if you look largely at this bill, it has a huge financial impact, both for government and both for the private sector. So it's important how that is managed, because we appreciate if government can really guarantee the difference prior in many mechanisms prior the expropriation and the valuation and the compensation. And we appreciate that the bill provides for an agreement for the compensation before the expropriation takes place, which is a good principle, and we appreciate that. But we must be mindful there is a possibility that the market value and the compensation amount may not be the same. More importantly, the liability that goes with that property that is being expropriated, and needs to make sure that we protect even to the extent that the banks are put in as a priority. That's very, very important. So we need to find a way, and I'm saying the Land Reform Act actually provides a fair principle in actually doing the valuation of determination of market value. So that's how we see this act legislation related. So it's important that it's managed. We have a big responsibility. Chairperson, your money is with the bank, and we need to really appreciate to protect that guarantee that your funds are safe. We must not give you stories about your money that's in the bank that you are holding. So this bill needs to really support that. Now, if that is done poorly, the determination of the compensation value, it will make it very difficult for banks to further extend loans to support business and to support commercial property acquisition. So that we must know that it is in place. So uncertainty in value properties will really make it difficult for banks to do its work, that is propelling and fueling the economy. Next slide, please. So one centrally, you'll hear that you can figure out already from my introductory slide that we have serious issues with Section 12 of the bill, and we have some suggestion that we need to have a good clarity in terms of what kind of properties will qualify for expropriation without compensation. And we're saying that we're cognizant that there is provision for that, but it might be, it definitely be a good idea to provide at least a principle that guides the determination of such, or a list of such properties. And then we need to know, well, that some clarity on specific instances where this is applicable, under what circumstances will this be applicable. So the wording in the introductory paragraph must be amended to limit the list that this closed list can apply, specifically Section 12 3A, which we've cited in below, and then Section 12 3B, where it says the minister should not be able. The minister should not be able. Should be able to remove the bill or provide clear parameters of the circumstances where used land, unused land will be included. For example, restricting the failure to use or develop land only to the circumstances referred in subparagraph B to E. And then going to section C, reference is made to failing to exercise control should be removed, and clear parameters should be included for the circumstances under which land is considered having been abandoned by the owner. Yeah. Next slide, please. So in conclusion, I know this product is very short, but I'm willing to engage a bit more, and I hope our point is very clear what our concerns are. We're saying land reform must be implemented faster and more effective, especially in urban areas where there are about 1.2 million that live in it. Uncertain property values will inhibit banks' ability to provide credit to residential property developers, buy-to-let investors, home buyers, tenants, placing greater demands on government to supply residential stock. And we know that government has challenges with regards to fiscus, and the private sector can play a big role in working with the government. And we need clear and crisp legislation to remove policy uncertainty and ensure that more than 230 state entities which are empowered to expropriate property do so in a transparent manner, aligned to Section 25. And we recognize that this bill actually has made a very good attempt to align with Section 25 of the Constitution, which makes it a lot easier for us to work with. And then finally, we're saying financial sector is really committed to work together with government in making this bill really practical and as fair as possible. And I also want to talk about, also we need to, as government and private sector, we need to reduce the trust deficit between the two parties. We need each other, and being clear and transparent in bills like this that are at the core of our business. It's very, very important. And we want to participate. We appreciate being consulted, and you will see that we are very protective and proactive in actually working with the state. That's what BASA stands for. And we want to continue to work with the committee in this area, in this bill work. So we have made our full presentation and submission, 37 pages, and there's a lot of details in that space that clarifies most of the issues. But in the high level, these are the issues that we want to raise with the committee for now. And I thank you, Chair, and honorable members for the time.
Thank you, Mr. Thabeni, for being that concise, very clear in terms of what BASA says in relation to the bill. Indeed, we were able to save us time, but the message is driven home. Thank you, Mr. Thabeni. Members, that was the last presentation. We have agreed that if there are any clarification questions that members would want to make, they are free to do that now. Remember that we started with the Mineral Council of South Africa, then it was the National Mineral Association of South Africa, then it was COSATU, then it was BASA. Those are the presentation that we received. Any engagement or clarification question that members might want to raise in relation to the presentation, but of course take into account the fact that we will have an opportunity to deliberate after the after the mandate has been received from the provinces. Any clarification question, members?
Nothing from our side, Mr. Chair.
Thank you. Honorable Prataseth, Honorable Khai, floor is yours.
Thank you very much, Honorable Chair. We welcome all the presentations. It's just as the Chair, there's last bus that leaves at 12:30, so we don't have enough time to get to Parliament. As I agree with you that we will engage when we deliberate a later stage. But just a question to Basa. I see that I take it that in principle they support the idea of expropriation without compensation. They are proposing a closed list. So I just want to find out whether in terms of their proposals, what sort of areas that they think the expropriation without compensation or nil compensation should apply. Then the National Employers Association, I hope I have the correct name. They talk about that this bill should be constitutional, but then within the constitution itself, there are certain sections that they want out that are in the constitution, and therefore the bill would be in terms of the framework of the constitution. For instance, we want to limit it to the land. Also, even on that, take away the issue of public interest. Yet that public interest issue is also in the constitution. So I just needed a clarity on that. But also that this should be limited to government land. Yet the constitution doesn't say which land, whether is it a private land or a government land. It just talks about proper expropriation for public good or public interests. It doesn't differentiate between the state land or the private land. So those are the concerns. When you talk about constitution, one should not be selective. Thank you, Chair.
Thank you, Honorable Khai. Maybe just to hear all the views, all the presenters in relation to what is their view in relation to the insertion of a provision that allows agreement to be reached between the parties based on a counter offer in response to a notice of intention to expropriate. This is quite critical because in the current version of the bill, after receiving the notice of intention to expropriate, the recipient must decide whether he or she accepts or disputes. If the amount of compensation is disputed, the person cannot make a counter offer, and instead the dispute resolution provision must be applied, and the parties must either mediate or go to court. So it's quite important just to get a sense from all the presenters what is their view in relation to this point. But of course, take into account the questions that Honorable Khai has posed to both the PASA and also the National Employment Association, which made presentation immediately after the Council of South Africa, the National Employers Association of South Africa. Questions were referred to these two by the Honorable Khai. But the question that I posed, all presenters can just share a view on that. Let's start first with the Mineral Council of South Africa. Ms. Brown.
Honourable Chair, apologies, I was struggling to unmute. With regard to your question, ideally, parties should be afforded an opportunity to agree on the amount of compensation. There is a provision in clause 19 of the bill that provides for the process of mediation and determination by the court. I think if the intention is that the parties through the mediation process then come to an agreement on the amount of compensation which will allow the owner or the holder of the right to make a counter offer, then obviously that issue can be factored into the mediation process. It might be an issue, that from a timing perspective, you don't want protracted delays where there's to and fro between the parties to come to an agreement, and hence, reference is made immediately to the mediation process that needs to be implemented to actually facilitate an opportunity to come to an agreement on the amount of compensation. So I think, although there's no specific provision for counteroffer, there is a process through which a counteroffer can be facilitated. Thank you, Chair.
Thank you, Ms. Brown. The National Employers Association of South Africa, which was Mr. Swart.
Chair, first of all, in respect to the first couple of questions, this question was asked to a previous speaker as well, and I think it was quite eloquent to answer. You have to look at the purpose of the bill. If the purpose of the bill is land reform, amongst others, as stated, then surely the focus should be on land. As we indicated, we find it difficult to foresee a situation where you will expropriate other intangible rights for purposes of land reform or to grant equitable access to natural resources. So the purpose of the bill limits the definition. Secondly, why we said only government property is we believe that where government property is unused and that is used for land reform, that will cause the least economic harm, that will possibly unlock economic opportunities for farmers, for businesses, whatever the case might be, without sacrificing property rights of private owners. And in terms of your question, Chair, like previously stated by other speakers, there is a provision for a mediation type of process, but without really applying my mind to it, I do not see a problem with a provision of a counter offer in order to try and settle the disputes surrounding the compensation in order to avoid disputes going to court. That will obviously fast track the process. Thank you, Chair.
Thank you, Mr. Swart. Mr. Parks.
No, thanks, Chen. Yeah, thanks to yourself, Honourable Khai. No, Chen, in terms of your question about insertion of an additional clause around an agreement relating to a counter offer, no, I think we'll support that, Chair. It makes sense. Because you want the whole purpose of the bill and the kind of detail around the facilitation and mediation, etc., is to try to facilitate that. You want a consensus. You don't want to be dragging issues into court because that's going to take time. It's going to cost everybody money. At the end of the day, there should be some way of resolving it. So that would make sense, Chair. And I think for us, we would assume that would be simple and easy to do. And I think it will help to enhance, to address any concerns, etc. And really, so people have the right to go to court, but ideally, we'd rather resolve it around a table discussion between the relevant party and the relevant state institution for everybody's benefit. I think precisely why the bill goes into such detail around the processes and the timeframes, the sequence, the recourse, etc., is exactly that. So I think that would make sense. I think it would enrich the bill, Chair. Then, Chair, on the constitutional obligations that Honourable Khai raised, look, I think people have taken a narrow interpretation of the Constitution. The Constitution is very thoughtfully written, very eloquently, very clear in many areas. Yes, to speak to compensation, there's no problem with that. Because, a teacher or a nurse who owns a house, she would want to be compensated when the municipality expands the freeway, etc. No problem. But equally, Chair, we shouldn't be selective around, I think as Honorable Khai was correctly saying, about the Constitution. The Constitution also is quite clear, it's very progressive. It said the state must advance land reform. It must ensure access to natural resources. It must ensure that access is equitable and there's equality, and it must specifically address the legacy of apartheid and colonialism, dispossession, etc. So we can't ignore those very foundational principles of the state. And I think the bill really seeks to kind of empower the state to advance those constitutional principles, which are really quite sacrosanct. Chair, that the Constitution says there should be compensation which must be fair and equitable. So it doesn't say that compensation must be simply based upon whatever price Honorable Khai or Matthew Parks wants, you know. And if we want 800 million rand for Mala Mala, it doesn't speak to that. It says fair and equitable. We're not sure how would 800 million rand for Mala Mala be fair or equitable, given that you have millions of people living in informal settlements, you have millions of people living in rural areas who don't own land, especially the poorest members of society. But I think, Chair, the bill is rational. It's gone through a lot of discussions. It's gone through it's about 4 rounds of parliamentary hearings at the fourth parliament and the 6th parliament, if I'm right, or the 5th parliament. Sorry, time catches up with me. 2 rounds of engagements at NETLAC. Business, BASA, Agri-SA all contributed very meaningfully to it. We were part of this engagement. The Department of Public Works, when they led these engagements, in this term and the previous term, they were very thoughtful. They went through, made many compromises that business had asked for, that we had asked for as organized labor. They were not rushing this thing. I think they were measured and they were reasonable. And this is not a blank check to the state. We don't want any state to be given a blank check because we know that people in state can abuse it. We have seen in municipalities how corrupt people collude with the municipal officials to expropriate and to make profit on the land. So we need to find the right balance. I think for us, Chair, the bill does provide the right balance. We're convinced, Chair, that it is in line with international norms, whether it's the United States or Europe, whether it's Japan or China or Russia, all countries have this thing. We need to have it because right now you have a bit of a Wild West. I think you've got about 130 different pieces of legislation, regulations which guide expropriation. So this is going to give a single processing for everybody to understand what are the rights, what are the processes. And we think, Chair, that we live in an era where President Cyril Ramaphosa is president. The law should reflect the values of the Constitution of 1996. We should not be having a law which reflects the values of B.J. Foster from 1975. That shouldn't be a complicated stance to make that we must update our laws. And I think, Chair, maybe also to assist, look, agriculture is very important to our country for food security. We're lucky to have a very diversified, sophisticated agricultural sector. It needs to be grown. It provides employment for about 800,000 farm workers directly, other hundreds of thousands workers in the food value chain. We don't think that the agricultural sector has anything to fear around the no compensation issue, because the criteria is quite clear. It's idle land, it's abandoned land, etc. So if the farm is not idle or abandoned, why should they fear then no compensation? If there's compensation, it will then follow the criteria set out quite eloquently in the bill. But the only people who would need to fear is people who have disappeared to Australia, who have abandoned the land. And of course, we should then be unashamedly advancing the interests of South Africans, especially the poor, for such instances. At times here, we've also seen, there was a case, I think, in the city of Cape Town, not to pick on the city of Cape Town, but just to give an example. I think the Department of Human Settlements wanted some land for housing. The city of Cape Town said, fine, you can have the land, but you must pay us, I think, 500 million rand or something like that, quite an exorbitant amount of money. So we think it's right that let's have some fair compromise on all parts. Let's have a fair thing which could really advance public interest, public needs, etc. But I think for us, Chair, this is a win-win compromise. It's sane, it's rational, and I don't think anybody should fear it. I think it's going to help empower the state, not going to resolve issues, but as a useful tool for the state going forward. I mean, it won't be a magic wand, but it's an additional useful tool to help accelerate land reform. So I think for us, Chair, we're confident in our support of it. It will pass constitutional muster. And I really would want to plead, Chair, for those who are opposed to it, to cool down the rhetoric, because we need to find a fair, sober compromise and not one which is going to polarize society on a very sensitive issue of land, because land is sensitive not only for farmers, but also for people who live in backyard dwellings, people who live in informal settlements, people who live in rural areas, etc. And they also need to have their legacies of exploitation and abuse addressed finally, Chair. Thanks very much, and thanks to members.
Thank you, brother. Let's then go to Mr. Dlamini on behalf of BASA.
Thank you, Chair. The question is about our view on expropriation without compensation. Which properties do we actually fall into that categories? We actually don't have the list, but I can tell you that we are against financing criminality. So any property that is acquired through criminal means or purported criminal activities should qualify for expropriation without compensation. That is very, very important because as a financial institution, we promote good business ethics, and we don't want to be led to be misled that properties are acquired to do a good and honest business. And if we find out that is the case, we would like to work with government in that space to expropriate without compensation. But clearly the details will be in the transactions and the amount that are involved. So that will be my response, Chair. As the previous speaker says, we acknowledge that the bill really is meant to do good for the country, and the government won't be reckless in the determination of qualifying assets or properties for expropriation. And we want to trust in that. We just say that if we can be consulted, it's very, very important. In the compensation space, when you're serving notice, put together a clear consultation process with the affected parties. And the banks are also affected parties in many cases where there is exposure, and governments has the database to determine that. We also would love to be consulted to work out on a solution for a third party. Thank you, Chair.
Thank you, Mr. Dlamini, for taking this opportunity to respond to some of the issues that were raised. Indeed, as a committee, we are enlightened in terms of the process thus far. It's important just to indicate to the members that there will be an opportunity for the Department of Public Works and Infrastructure to respond. I think that will be on the 25th of October, where the responses will be given both oral and written submissions in relation to the bill, in relation to all the presentations that were made, right, from the first time when we met and now. I think one may reflect on the fact that this is a process to relook at the Expropriation Act 63 of 1975, which is a pre-constitutional order legislation, and therefore there is a need for this expropriation law to be aligned to the constitutional principles. I think that came out quite clear from presenters. And today we had an opportunity to hear from a range of stakeholders across various sectors, including, among others, the community organization, the organized labor, organized business, SERI, and others, but also the Mineral Council of South Africa and YASA, in terms of their views. Clearly, there are concrete recommendations that the stakeholders made today. either in support of the object of the bill, but also there were reflections made in relation to pursuant to the bill. What is quite clear also is that as part of the engagement, the Department of Public Works had indeed alerted the committee to the fact that the role of the bill in respect of the land reform will be enhanced if its application is to be extended to expropriation for the benefit of third parties. But more than that, like as indicated, on the 24th of October, the department will provide detailed responses to both oral and written submissions on the bill. And as a select committee, we want to take this opportunity to indeed express our appreciation to all our stakeholders who heeded an invite to this public hearing. More so those that addressed us today. We really extend our hand of gratitude to all of you. And with those few words, allow me also then to thank our members, the department, the parliamentary staff, from the committee secretary, the content advisor, and also the researchers for the effort that they took in terms of creating this necessary platform for us as a committee to engage with these critical stakeholders for the purpose of ensuring that this bill is enthused and it's also informed by the input from our critical relevant stakeholders. So therefore, the meeting stands adjourned. Thank you, honorable members, and also the media, PMG. Your presence is highly appreciated. Thank you.
Thank you, Chair.
Recording stopped.